Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. My name is William Meade. Sitting with me today are Justices Hershfang and D'Angelo. If you haven't been here before, you should know that we've read everything, and each side gets 15 minutes. My best advice is to get right to the point. We do not entertain any rebuttal. With that, I'll call our first case, which is impounded. So please refrain from using any names. And it is Commonwealth versus a juvenile, 22P112.
Good morning. May it please the court, Caroline Alpert for the juvenile, who is present here with his mother. The juvenile did not knowingly waive his right to a jury trial because at the time of the waiver, he did not know that the court would alter the maximum sentence. In juvenile court, the timing of trial determines what the maximum sentence is. And in this particular case, the juvenile waived a jury so that he could have his trial before his 18th birthday and therefore have a maximum sentence of a commitment to 18. Had he known that after the adjudication, the court was going to artificially delay sentencing in order to impose a different maximum sentence, a commitment to 19, he very may well have decided to wait the extra couple weeks to have a jury trial. And so this case is different. There's an adult case that talks about the issue of knowledge of consequences in a jury waiver, Commonwealth versus Bertie. But I want to note that it's very different in the juvenile context than in the adult context. What's discussed in Bertie is that the minimum and maximum sentence for an adult is the same, regardless of whether they have a jury trial or a bench trial. And so there was an error said during the colloquy about the minimum sentence, but ultimately that didn't impact the waiver because it wasn't relevant to the decision of whether to waive a jury or not.
Counsel, you said at the beginning of your argument that the juvenile did that on purpose. Is that in the record anywhere? Is there an affidavit of him or of counsel that that's why he did the trial so early?
So there's no affidavit, but there is the sentencing memorandum from the juvenile, and what's stated in that is that originally, so between that and the record, what we know is that originally the jury trial was scheduled for April. Due to various COVID issues and the inability to have certain jury trials, it got delayed again to the end of July past his 18th birthday. And in the sentencing memorandum, what the juvenile states is that once that got scheduled past his birthday, that's when he decided to instead waive a jury, and that gave him the ability to then move the case back before his birthday to have a bench trial. So we see that the scheduling of this is very much tied to whether he's going to have a jury trial or a bench trial.
Is there anything in the record that would indicate that a jury trial would have taken longer?
Well, we have the fact that because he told the court, I'll have a bench trial instead, they then moved the case back to before his birthday. And I think also the various discussions about the COVID protocol, that this particular case wasn't in the particular phase of jury trials at that time, so that's why it was going to be, I think it was scheduled for July 6th, which was a week or two, July 26th, which was a week or two after his birthday. He said, all right, fine, I'll have a bench trial, and I think it gets moved to June 23rd, so before his birthday. So we can see that this is all an interrelated decision, and as a result, he needed to know that the court was maybe going to entertain a longer, different commitment regardless of when the trial concluded.
Yeah, I mean, you referred to the continuance as artificial, but I think it was quite real and intentional, and they said they wanted to do it so he could be kept until he was 19 to rehabilitate him.
Yes, Your Honor is correct. And when I said I I agree that it was intentional. It's very explicit, the reasoning. When I said artificial, what I meant is that it wasn't in the orderly processing, the kinds of things that are discussed in the Noah N. case, the typical reasons why there would be a delay in sentencing. For example, if this was a youthful offender case that requires a pre-sentence report, the juvenile knows that there's going to be a gap because the probation department has to conduct this type of extensive report, or if there was going to be an evaluation, or if the victim wasn't present and they had to wait for a time. So if there was a legitimate reason to the orderly way that cases proceed, that would be different. But here it's explicit. The case could have been sentenced on that day. The Commonwealth requested and the court allowed them to move it for the sole purpose of imposing this longer sentence. And the argument is that the juvenile needed to know that at the time that he could effectively utilize that information. And so embedded in this argument is also a due process.
Well, he would have known at the time they moved for the continuance. I mean, the Commonwealth wasn't hiding its cards. It said it flat out what it was doing.
It said that after the trial concluded and after he was adjudicated. He needed to know that before he decided to waive the jury, to have it at that time. And so the due process argument that comes in here is that you need to have notice of a sentencing enhancement.
Was the due process argument raised below?
No. But it is a pure legal argument, and so I think this court can still consider it de novo.
Well, yeah, but under the substantial risk standard, though.
Sure, but I think arguably the fact that the juvenile, the decision, well, I think separately it's important to note that we're talking about a constitutional waiver here.
Yeah, but you don't have any issue with the waiver vis-a-vis his knowledge or the volition of it. You're just saying he didn't understand that he may face a longer sentence.
Right, he didn't know that even if I have this trial, so his thought process is, I'm going to waive my jury so I can have this trial sooner. My maximum sentence is going to be a commitment to 18. He didn't know that the court...
Which was 8 days, right?
I think it was a couple weeks. It was June 25th to his birthday was July 15th. So, sure, I'll give you that, but still, that's the way the statute is written. And the point is that if he knew, well, I might be exposed to this commitment to 19 regardless, then maybe he would have waited the extra month to have the jury trial. And so the knowledge is necessary at the time of the waiver, and this is where the due process argument comes in, which is that what due process requires is notice of sentencing enhancements at a time that you can effectively utilize that information. So
go ahead.
I think, if I remember correctly, you cite Apprendi for that proposition, the federal case. Is there a state case or a federal case applying, though I don't know how it'd be federal, interpreting this as by this I mean a longer period, a statutorily longer period depending on age at the time of sentencing, as a sentencing enhancement?
So I think generally our cases that deal with Apprendi issues say that a longer sentence is a sentencing enhancement. So for example, the Armed Career Criminal or some of these other habitual offender acts, if it's going to result in a longer sentence, that's considered a sentencing enhancement and therefore requires Apprendi. And there is a juvenile case, again, there's nothing that directly addresses this issue, but there's a juvenile case, I believe it's Quincy Q, I want to double check that. I do cite it in my brief, which talks about Apprendi as applied to youthful offender proceedings. And in that case, when there's a youthful offender case, that means that the sentence, it could be an adult sentence or it could just be a longer DYS. So if you're a YO, you can be committed to DYS until 21. And in that case, the court said we need to apply the Apprendi standard to this YO determination.
Isn't Apprendi different, though, in that there the Supreme Court had the issue with fact-finding by the judge after a jury trial, whereas this is a bench trial, and the judge was the fact-finder?
So I think, generally, our cases that deal with Apprendi issues say that a longer sentence is a sentencing enhancement. So for example, the Armed Career Criminal or some of these other habitual offender acts, if it's going to result in a longer sentence, that's considered a sentencing enhancement. And Sure, but this would be a separate determination after the fact. But even if it was still in front of a judge, we still have the issue of the standard, which is should be beyond a reasonable doubt, which is a much more stringent standard than clear and convincing evidence.
Beyond a reasonable doubt for the continuance?
Sorry, so this gets us into the Noah N issue.
Yeah, let's get to the NON,
So,
which we know you argued.
I'm sorry?
You argued.
I
right?
did. So with the Noah N issue, if you're going to have a continuance for this explicit purpose to gain the longer sentence, you need to have this particularized hearing where the Commonwealth has the burden, and what they need to prove is that longer treatment is necessary for the juvenile's rehabilitation.
Right.
And so my argument here is that shouldn't be a clear and convincing standard. That should be beyond a reasonable doubt standard because it's a sentencing enhancement.
Well, that's not what the SJC said in Noah N, right?
Correct, but I am challenging that because I don't think that's the correct standard based on the fact
We'll
that we're.
have to ask them.
I assumed as much, but.
Why isn't it moot?
It's not moot because of Noah N. Now when you have someone who's had their case continued to have this extended commitment, that has implicit with it a finding. And so when there's a finding that carries a particular stigma to both the juvenile and to other court personnel, if, hopefully not, but if for some reason he ended up in adult court now, they're going to see that. That now carries.
The effect is adjudication as delinquent, though.
It doesn't affect, no, it doesn't affect this current.
And he's already served the year.
Correct.
He finished it almost a year ago, I think.
Correct.
Or over a year ago.
Yes. The issue is if for some
But
reason.
what's your remedy?
For which part?
For the continuance of a year, or I'm sorry, for the extra year he did that you said he shouldn't have done.
So the remedy is that the continuance was an abuse of discretion because it did not comply with Noah N. Obviously, Noah N didn't exist at the time, but in the Noah N case.
But it applies.
It applies.
Because this case is pending on direct appeal.
Yes. And in the Noah N case, the SJC said, the court didn't do this. Of course, they didn't do this. This didn't exist, but we're still going to find an abuse of discretion.
So should we remand it for a Noah N hearing?
So both the Commonwealth and I agree that there should not be a remand, albeit for different reasons. The Commonwealth thinks so because
Judicial economy?
moot. And I think for, well, several reasons. Judicial economy, to then have to bring back in all these juveniles for who knows how long to appoint counsel, figure out what information would have been relevant at the time regarding treatment needs.
No, not all of these juveniles, just this fellow.
Well, okay, the Commonwealth argues that.
It applies and it has to have been preserved, which is the case here.
Sure. But separately, there's an issue of the ex post facto law, which is that because Noah N didn't apply at the time, again, this gets back to what was the knowledge of the juvenile at the time that he's making these decisions about his case. He had no idea that this was a possibility. And so to now imply a sentencing enhancement in the past that didn't exist would be an ex post facto application.
I ask about that. You say that he didn't know it as a possibility. So whose mistake was it? Was it the judge's mistake in the colloquy not to inform the juvenile that this was a possibility? Or was it his lawyer's mistake not to let the juvenile know this was a possibility? And if it's the second one, I don't believe you argued ineffective assistance of counsel.
No, I have not argued ineffective at this time. And the reason being that because Noah N was not in existence at the time, the reading of the statute at the time was if your case is disposed of before 18, the maximum commitment is a commitment to 18. So a clear reading of that is we better resolve this before your 18th birthday, and that will limit the maximum sentence. It's different now because of Noah N. Of course, attorneys should be advising their clients that this is now a possibility, there would have to be this hearing, et cetera, et cetera. But that also brings up this notice issue, which is that you need to have notice of a sentencing enhancement at the time you can use it. So for example, in Wentworth and Pagan, those cases require, in the adult context, notice of a sentencing enhancement at the indictment. I'm not even getting that far here. I'm just saying at minimum you need to know before you're waiving a jury when that's related to how the strategy of timing your trial.
But are you saying that this case is a complete anomaly, even though the same thing happened in Noah N And you're telling us it's never happened in other cases where the Commonwealth sought a continuance to get a longer commitment?
I don't think it's a complete anomaly. Obviously, it has happened before. I don't think I can comment on whether it's a common practice, and I think it's also a rare situation that you have a trial that's coming this close up to the birthday, perhaps, but I don't think I can speak to the number.
Well,
But
there's
I-
also the element of COVID. It's the 800-pound gorilla in the room. That
Sure.
None of this would have happened if everything hadn't been delayed because of COVID.
Exactly. In the case, it's a good thing. Thank you, Your Honor, for reminding me that this case was pending for nearly 4 years. I mean, the offense was committed when he was 13.
Why doesn't that make it unique and to be left alone, as it cannot be repeated, God willing?
Well, because it could be, well, there might be other circumstances. I think it's rare, so I don't think a ruling by this court that in this particular case, the jury waiver is null is all of a sudden going to bring in all these cases that are going to have the same issue. I think this is a particular
I thought
case,
we covered that already.
Okay.
Wouldn't apply to those unless it was preserved.
Right. There is also a lot to discuss regarding the errors at trial. I see I'm out of time. I don't know if there are particular questions or if how the court wants to proceed.
No? Seeing none, thank you.
Okay. Then I rest on my brief that there was a significant amount of pervasive, repetitive, improper credibility evidence that occurred at the trial. And even though it was a bench trial, what we know is that from his written findings of fact is that the judge did consider all the evidence. There was no discussion about limiting instructions.
Your time is up.
Thank you.
Ms. Lyman.
Good morning, and may it please the court. Ms. Mackenzie Slyman, arguing on behalf of the Commonwealth. If I may, I'll start where the court left off with counsel at the issue of Noah N. I think this starts and ends with the fact that even though the Commonwealth agrees that the decision in Noah N is retroactive to this defendant, at this point in time it is a moot issue. I think it's especially important to note that a remand, a reversal of the continuance by no means affects the adjudication of delinquency. I think the argument that any stigma attached to the length of the commitment, especially when you take into consideration how DYS commitment works, where it's not a situation where there's a guarantee that an individual is in, a locked facility in actual custody. DYS has the ability to kind of craft whatever rehabilitative.
Since it's not punishment, can it be considered in a hypothetical future case for sentencing purposes?
It's an interesting question, Your Honor. I think when you look at how juvenile cases can potentially serve as predicates for ACC, I think it could be in that situation. However, the charges of this defendant, from my quick look at ACC and the case law, his offenses would not be, his delinquencies would not be able to serve as predicates. They don't meet the requirements of a crime of violence and, deadly weapon and all that. So while I think that there is a situation where a juvenile adjudication of delinquency could be considered, this is not one for the purposes of future sentencing, which appears to be the juvenile's concern at this point. As Your Honor pointed out as well, Noah N. was not dealing with, first and foremost, a situation where someone had already been adjudicated delinquent. In Noah N., it was an individual who hadn't pled out their case or made their agreement yet.
It was interlocutory too, right?
Correct. It was interlocutory.
We don't know what they would have done.
Correct. And that was a situation where by the time the SJC had issued that opinion, the juvenile in that case had already obtained the age of 18. So, there wasn't the Commonwealth could not have revived the case against them at that point. But I think as Your Honor...
Do you know what, I know the ADA who wrote the brief also argued it. Do you know what happened when it went back?
I don't recall, Your Honor. I did inquire with ADA Hartley, and I apologize. I don't recall what her response there. I don't believe, and my understanding of juvenile law as it is, I don't think that the Commonwealth would have been able to. to go forward on the case at that point because the juvenile had obtained the age of 18. So where the continuance had been reversed, I assume, and I apologize for my lack of practical juvenile experience, I don't know if it was a null process that would have been followed or if how things proceed once an individual ages out. I don't know how that would have proceeded, but that's my estimation of what would have happened. But I think, as Your Honor pointed out, Noah N. wasn't also explicitly addressing the COVID of it all and what a unique situation that was to these cases. The trial judge here, I think that was a large part of his rationale, again, with the focus on the purpose here of being rehabilitation, that the only reason we were this close to the juvenile's birthday was due to large continuances because of COVID. And you take that part of it kind of, an objective reason for those delays, not attributable to either party. You take that and alongside the severity of the offenses here, the brutality of them, the deliberate way they were carried out, and at 17, I think it's 17 days is how long the juvenile could have been committed before his birthday. The interest there of justice, but also of rehabilitation is nil.
What do we make? Noah N. is decided, and the juvenile comes back and says, "Oh, Noah N." And the judge goes, "Oh, it doesn't matter," or words to that effect.
Sure. So had we been in this, had we been an oral argument by the time, and the juvenile had still been in DYS custody, I think the Commonwealth's argument in its brief of this case being remanded for a hearing would be appropriate. But since the juvenile no longer is in any sort of commitment, and where, frankly, after reviewing the briefing on this, this had been previously briefed last summer and then had to be rebriefed. But at that point in time, we're now a year out from Noah N. So any juvenile who was in a commitment because of a continuance past their birthday, at most was going to get 365 days, right, up to their next birthday from 18 to 19.
Wouldn't it have been better for the judge to have had a Noah N. hearing at that point?
Of course, it would be better. I don't think we'd be here today, but I think the absence of that does not negate the fact that it is moot now. And I think the judge's decision.
He did make some findings, right?
He did. There wasn't an evidentiary hearing, but he did have a non-evidentiary hearing where the parties were able to submit memos about sentencing. The parties were able to argue for why a continuance was appropriate. And the judge made very thorough findings there from what the parties put forward, where there was thoughtful contemplation about the, again, extent of rehabilitation possible in the 17 days that the court had available to them. I do not have the advantage of counsel or ADA Hartley of having argued Noah N., so I don't know the full background of that case as well. But I don't know that the judge in that case articulated as thorough of findings and reflected that there was a thoughtful contemplation as there was here. So I think that minimizes any possible consideration of prejudice or any prejudice for this staying as it is at this point. If the court has no further questions on Noah N., I'll turn next to the jury waiver question, which again I think is predicated on Noah N. But I think the focus needs to remain on what you are waiving when it comes to a jury trial, and that is your rights as it relates to trial. Sentencing is separate from that. I would point out as well with Noah N. that the SJC did not use that as a vehicle to say that this mechanism was not available, or that every prior case in which a continuance was sought to expand the abilities to rehabilitate a juvenile, that it was improper. So with that in mind, it was entirely proper at the time prior to Noah N. without that additional guidance for judges to issue continuances to this effect. So the juvenile was in a position to know that was a possibility. Moreover, I disagree with classifying this the same way as a sentencing enhancement, because the juvenile clearly knew that had the bench trial taken place after his 18th birthday, had it started and ended past his birthday, had a jury trial started and ended past his 18th birthday, he was going to be facing committed time of up to 19. So he knew the entire time what the true maximum of exposure, I suppose, he was facing on this case.
Well, but to take your sister's point, assume for the moment that he knew, because he was presumably well counseled, that juveniles who are adjudicated after their 18th birthday face the potential of being up to 19, and then deliberately made a choice about the type of adjudication he would have so as to limit that possibility. I guess my real question is, are you saying that the knowledge is sufficient, and in fact, perhaps even having deliberately tried to accelerate the trial because of the knowledge shows that he was given the process he was due? In other words, he only needed to know, and the fact that he tried his best to keep that from happening doesn't mean that he didn't know.
I would agree exactly, Your Honor. I think that in that situation, that the juvenile was provided the information that was relevant and that reaches the threshold of his ultimate decision to elect to go forward on a bench trial that renders that decision knowing and intelligent. And I would point out as well, I think as the court has mentioned, we do not have a situation where we have an affidavit from the juvenile that there had been, a separate hearing in front of that court as to, an ineffective assistance claim. What advice were you given? What did you do with the advice that you're claiming to have received? And I think as well, and the Commonwealth does mention it in its brief, that there really isn't, I don't want to say no point, but it's not a good utilization of time for the parties to have first contemplated this potential continuance and whether or not that the judge would do that prior to trial, because as is reflected here in the judge's decisions, a lot of that was predicated on what he learned about the offenses at the trial. So any hearing taking place before that, if the juvenile is suggesting that there should have been some kind of proceeding before the judge, before the bench trial commenced, so that he would know definitively whether or not the judge would push this past his 18th birthday, that it wouldn't have been a fruitful hearing because of the fact that the judge was going to be dependent on the facts as they developed at trial to assess the severity of the offense. Frankly, I think he would have to, right? Because if that's going to be part of his factor, how can the judge say, based on just merely the charge alone, that I've already made the choice to extend this. So I think any hearing that would have taken place prior to that would not have been use of judicial resources, and I don't think would carry the day on the other side of things. If the court has no further questions, I know the counsel wasn't asked about any of the evidentiary.
One related to a different issue. The first complaint claim, the SANE nurse testified as to the SANE protocol.
Correct.
Did the SANE report come into evidence as an exhibit?
I believe it did.
Was it redacted?
It was not redacted. It's also my recollection that there wasn't an objection by counsel,
Right.
or at least not one specific to whether redactions were made. So if the court was contemplating that, I think we'd be in the substantial risk part of it. I acknowledge, Dargan, that the law of the land is that these mentions should be redacted, but I think when you look at the entirety of the purpose of why they went in, it details what the SANE nurse had already testified to, of what the process is. It details not necessarily, the focus isn't entirely on the allegations of the sexual assault, but whereas here the juvenile was also charged with the assault and battery with the knife of the victim, the records reflected the injuries that she had sustained, that it's just reflecting the medical treatment she received and what injuries were documented at that time. And lastly, as we are aware, this was a bench trial. The court presumes that the judge was properly instructed on what he could and could not consider. Absent evidence to the contrary, there is no evidence to the contrary here, that the judge would have taken this at a separate value. And I think especially circling back to the strength of the Commonwealth's case, that the abundance of witnesses to the chain of events that took place here. This isn't a situation where the contents of the SANE report are what launched this over the threshold to getting an adjudication.
I have two evidentiary points. The detective testified that the juvenile, because of, I think, a footprint or something, appeared to be stalking the area. And your argument is that's proper lay opinion. How is that proper lay opinion?
Sure, and if I can, so there's two separate statements that the defendant takes exception to. So the toilet paper dispenser statement is of a shoe print left on the toilet paper dispenser in the bathroom. Separate to that, the detective testifying about, I think in relation to the surveillance video, testifies that that the defendant was, that the same individual hanging around the hallway to the bathroom appears to be kind of just stalking the area, looking around. I would suggest, to the stalking part of it, that was not I think it was more the colloquial use of the word stalking, not suggesting criminal behavior. I think it was more of a verb usage of, skulking around, moving around, stealthily, that kind of description, which I think would be within lay opinion. It's not something, my point being, I don't think that I think a fair reading of the transcript is not that it was implying any separate criminal behavior, that it was just more of a verb being used to describe the defendant's the juvenile, his mannerisms in that hallway. Beyond that, that testimony either about the toilet paper dispenser or the use of the word stalking, neither of that goes to as expressing an opinion about the ultimate issue here of whether the rape occurred. So, while it's not where it doesn't go to the core issue here, I think that any concern of prejudice is completely minimal.
The Commonwealth objects to the defendant arguing self-defense, and the argument at the trial level was that they were not on proper notice. The lawyer mentions it in opening statement. There's no objection from the Commonwealth at that point. The trial proceeds. The juvenile doesn't present any additional evidence. He simply wants to argue it. Under the rules, why isn't that permissible based on the evidence that was permitted at trial?
I'm not sure I understand your question, Your Honor.
The rules of procedure say that a defendant or a juvenile is going to assert a self-defense claim. The government has to be on notice.
Correct.
So first, why isn't the government put on notice during their opening statement? And if they had a problem about it, they should have objected at that time. So why isn't that a waiver, even during the trial? And secondly, does there need to be any notice if the defense just wants to argue it based on evidence that came in during the trial and doesn't introduce any additional evidence?
So to answer your second question first, Your Honor, I would say yes to that, because the Commonwealth put in the evidence that it thought was appropriate, that had been prepared well in advance of trial. Even if the Commonwealth was put on notice during openings, I would argue that was far too late. And at that point in time, the Commonwealth had planned their case, not anticipating, not being put on notice that we might need more information in order to respond to an ephemeral argument of self-defense. But the Commonwealth presented the case it presented and prepared and had prepped their witnesses for, what have you, and got the exhibits ready without having been put on notice that the defendant, the juvenile, even if he didn't intend to put in additional evidence, they couldn't even know that ahead of time, right? But they weren't in a position to be prepared for in the event that he raises self-defense. What else should we be preparing our witnesses to testify to? What other evidence do we need to just have at the ready to respond to that? I don't think that I don't think waiver happened in the opening, and I think I think, again, we would be in a much better position had the Commonwealth objected at that point, but the Commonwealth did lodge the objection during trial.
I think we're going to hold it there.
Sure.
Thank you both.
Thank you very
Very
much.
well argued. Thank you. We'll take an inordinate pause before I call the next case.
I think it's ordinate.
What's inordinate?
You can count it.
I never pause. So bad.
Does anyone else want to leave?
How are we doing, Tom? The next case is 22P 896, Commonwealth versus Griffith. Mr. Conley.
Good morning, Your Honors. May it please the Court, Alex Conley for Mr. Griffith. Your Honors, this case presents basically 6 distinct issues, we're all entitling Mr. Griffith to a new trial. And I'll just go through them one by one in the same order I did in my brief at this point. The first.
We've read your brief, so Correct. Go right ahead.
So the first issue is ineffective assistance argument here. This was a basis for motion for new trial where the non-prosecution agreement was entered into evidence by the defense counsel with the line that Mr. Griffith has been charged with a number of offenses, including a violation of restraining order. I suggest that this case is very much applicable. A very much applicable case here is Commonwealth v. Day. And Commonwealth v. Day is the case where the defense attorney presented a wanted poster of the individual for purposes of identification, for contesting identification with additional charges, which were not the charges which the defendant in Day was on trial. This, I'd suggest, is very much the same here, and where that case found this was ineffective, it was prejudicial. Here we have the same thing. A charge which Mr. Griffith was not on trial for was introduced into evidence by defense counsel. I think that the motion...
Now, so the agreement was redacted several weeks before trial, and that charge was null prost right before trial, right?
Correct.
So the judge, she said it was an oversight.
It is an oversight. I don't think an oversight means it can't be an effective assistance since it's an oversight. This is an ordinary fallible attorney. Would they have made this oversight?
Well, I mean, I think anyone who's tried cases knows that the run-up to trial involves, unfortunately, despite best efforts, a fair number of oversights here and there. So why isn't that ordinary and fallible?
I think because of the nature of this oversight. This is the defense's own exhibit he is introducing into it, which has a an uncharged conduct basically on there, or not uncharged, but not the charge for which he is on trial. I think the nature of that type of oversight is significant, not just a mere something which could be explained as, oh, I should have known better. It's, I'm introducing evidence of my client's prior bad act, basically.
Is there any indication in the record that either defense counsel or the Commonwealth or a witness or the judge ever called the jury's attention to those words at the top of that agreement?
No, Your Honor, I don't believe there's any indication that it was called attention to or made an important part of the case. That said, other bad acts were kind of part and parcel of the case. So when
Before you get to those, the judge did say the defendant is not charged with committing any crimes other than those charged in the complaints. And then relative to bad acts, she says they cannot be substituted as proof that he committed the crimes charged.
Certainly, and obviously jurors are expected to follow instructions. However, at some point, when there's enough bad act evidence in, the case law is clear. You can have a jury that's tainted by bad acts. I mean, the standards are different.
Well, first, they would have to be improperly admitted as bad acts.
Correct. They would have to be improperly admitted as bad acts, and I think that kind of goes into the second issue in my brief, which talks about the number of bad acts that were in this trial. You look at all the bad acts, and I think at some point, and the Commonwealth would suggest in their brief that these are kind of briefly mentioned and not drawn attention to, but we have basically an uncharged rape coming into trial. We basically have two instances of the jury being informed that the defendant is on probation. Another instance of being informed.
Those were objected to and struck, though.
They were, and a motion for mistrial was made. And I think that's where that issue comes into whether the mistrial should have been granted. If not for the first mention of probation.
That's an abuse of discretion standard, and the judge told the jury when she strikes evidence that it's not before them.
Certainly, it is an abuse of discretion standard. I'd agree. But the language used in most case law for when a mistrial is appropriate is often, was the evidence heard again? And I think that it was an abuse of discretion where the probation status of the defendant was heard twice.
She told him it wasn't evidence.
But it was heard. So a mistrial is based on...
Yeah, we'd have to reverse everything if struck evidence is reversible error.
True, Your Honor, but we'd also have to not reverse anything if it can never be a reversible error.
No, you have to show prejudice.
Certainly, and that's where I think when you look at the case here and kind of the way the facts were coming into evidence and the theory at trial is where the prejudice comes in here. The defense's theory at trial was we have a witness who's not credible and no real, hard, concrete evidence tying Mr. Griffith to doing these actions other than her testimony.
Well, I mean,
No, go ahead.
I don't think that's an accurate representation of the record. There were text messages, correct?
There were text messages.
There were calls to the victim's brother.
Yes.
Calls to the victim's former partner. There was a video that was sent to the victim of things in her home that belonged to her and her child being, electronics in a bathtub with water. And I think your response to that is, well, those came from unknown phone numbers, right? But it's not only the victim's testimony that tied the unknown phone numbers. So I think you're arguing more than you need to when you say it all depended on her credibility. There was a lot of evidence that was collateral. It may have tied back in some way to her credibility. But the brother testified that he got these messages from the person, he got a call from someone that he recognized as the defendant saying, have your sister call me. So I think that the breadth of the evidence is greater than you are giving it credit for.
I understand, Your Honor. And I do think, as you mentioned, all of that ultimately does tie back to whether she was honest or the other witnesses were credible. There wasn't nobody played these phone calls into evidence. There was no phone number or authentication of this being Mr. Griffith's phone number, just that witness saying, I knew it was Mr. Griffith because he's the only one who would do that. I don't have
Didn't she testify that she recognized his voice?
She testified that, and that again comes to credibility because it's her own testimony as to.
You talked about he wasn't able to testify given his criminal record, but in addition to the enumeration of the great evidence in support of the conviction, there's nothing in the affidavit that says what he would have testified to.
That's correct, Your Honor. And in Commonwealth v. Little, they talk about that it's not necessary for an offer of proof to be made for what you would have testified to if you've been able to testify. You can show prejudice without showing exactly what you would have testified to. I think the inference to be made in this case is that there could have been evidence that would have been the jury's determination as to who was the credible source here. Clearly, this was something that was contemplated to testify because this was a well-litigated motion in limine as to whether or not these prior convictions can come in.
Do you have a case that supports the proposition that you can show prejudice by saying that you would have been able to create a dispute as to credibility between two percipient witnesses? Is that prejudice?
I don't have a specific case that says that. I think the case law involving showing prejudice from prior convictions to be used for impeachment shows that there is no, as I mentioned, no need for an offer of proof to say what will come in. And so I think it's just by inference and extrapolation, a credibility issue where this is a key factor in the case is what happened, he said, she said versus just a she said. It can be inferred from that. I don't have a specific case to answer.
So you think we can just infer prejudice?
I think you can look at the facts of the case and determine whether or not his testimony his lack of testimony could have prejudiced him, especially where this is an objected to issue and preserved well in the record that he wanted to testify.
I want to ask you a question about the factual background for the statement by the victim that I'd refuse to have sex and he would force his way, which is one of the bad acts you are concerned with. I can't really quite understand the scope of the judge's ruling on that. It is included in the record appendix, and the judge allows testimony contained in the first bullet point of the Commonwealth supplemental motion in limine to introduce prior bad acts. I don't think we have that motion in the record. I've been unable to find it. It may still be there. I'm not that good at finding things, but I did look. But the judge also says it's not objected to by the defendant. And my reading of the hearing and the filing, which I think is at page 58 of the record appendix, is that the defendant did object. He didn't object to testimony about the nature of their relationship, but he objected specifically to testimony about this attempted, forced sexual interaction. Can you refer me to anywhere else in the record that can help me figure out both parties seem to say that this evidence was allowed, so maybe that's the end of it. Is there another ruling I'm missing in which the judge deals with the forced sex portion of the testimony about the relationship?
I don't believe so, Your Honor. I think there was the filings that were made where defense counsel, as you say, clearly did object to this testimony. In her written decision, the trial judge said he didn't, but in the transcript, I think is where you see the thrust of this argument being made, and the judge, when he decides, just says, without, and that's part of the error in her decision here, is that she didn't say there's a balancing. Here's the required balancing for prejudice versus probative value, and instead just allows this in. I think the only other place where I think this was noted again, and the trial judge actually tried to clarify her findings, was in the decision on the motion for new trial. Because the bad acts were again raised at that point, she in her findings there indicated various bases, some of which were just saying it was found to be more probative and also relevant to the stalking charge, which some of which weren't even raised at the trial level. But I don't think there's anything else in the record specifically dealing with that particular issue.
Okay, so for the purposes of our thinking about the ruling on that particular piece of evidence, I will ask you this as well. I take it the parties agree that it was admitted over the defendant's objection as a result of a motion in limine.
The objection is quite clear in the motion in limine. At the opposition to the Commonwealth motion in limine, there was an objection as well as on the record. So as far as applying the standard here, we'd be looking at the prejudicial error standard.
Counsel, can I go back to the impeachment evidence that you
Yes.
say regarding the defendant testifying? Is it your argument that if we find it was error for the judge to include, and I'm going to be specific, the assault and battery conviction, what is our review of that? If we find it's error, now what do we do?
So I think the review uses the prejudicial error standard. I know in prior case law, and I mentioned this is usually a substantial risk of miscarriage of justice for this type of issue, but most of those cases, and all the cases I found, were pre-Grady decisions. And so with Grady in mind now, I think the standard is a prejudicial error. So under that standard is what I think this court should apply to determine whether his lack of testimony would result in prejudicial error. Was it something that could have been affected the jury? And I think that it's hard for me to imagine that a defendant testifying as to anything that could have explained something would not be something that would have affected the jury or had but very little effect. I think in trial cases, a defendant's testimony is often some of the most important evidence and will certainly have an effect upon the jury.
So here's my issue with that. I always try to think of the future. So anytime a judge potentially makes an error regarding a prior conviction of the defendant doesn't testify, we're supposed to automatically reverse. Because if it's a prejudicial error, once we find that the judge was in error of not excluding that conviction, you're saying it's reversible error.
I think it still would depend on the weight of the evidence and the facts of the case. And I think if this case were just the assault and battery conviction, I might be in a different position because he was acquitted of the assault and battery on a family or household member. But this is not just the assault and battery. It's assault and battery. It's the wanton destruction of the malicious destruction of property.
Wouldn't the fact that he's acquitted on assault and battery on a household member indicate that the jury was quite careful in following the judge's instructions and not prejudiced by the bad act evidence that you said that was improperly admitted?
Your Honor, I think that's something that could have been a factor. I don't know that I can look into the minds of the jurors to determine why they found
No, that's why
that.
we have a presumption that they follow instructions.
Correct. I think that the evidence as to that, there was basically self-defense type arguments that could have been in the jury's head or not specifically made, but as well as a non-prosecution agreement, which kind of puts her at reason why she wouldn't be telling the truth about that versus the other ones. So I think there are factors there.
On the non-prosecution agreement, isn't it the defendant who brought up on cross what the contents of the agreement?
No, Your Honor, and I think that's an important point, is the defendant did not, he just introduced it through the witness. He did not cross-examine her on it. And that is where the vouching issue comes in. The case law is clear. If the defense counsel cross-examines the alleged victim on the non-prosecution agreement's contents and her lack of candor or because of it, then the Commonwealth has the right to
Wasn't that how he opened?
It's how he opened, but it's not cross-examination. That's basically what the case law says. If the defense cross-examines the individual trying to do it, then the defense, otherwise just argument in closing and opening, not actual evidence. There's no testimony as to her ability to tell the truth. And even the agreement here was redacted to get rid of the portions of the agreement which said she's agreeing to tell the truth. So the first and only time that it's really coming into evidence is through the prosecution's own vouching questioning, saying, "You've agreed to tell the truth, right?" And she says, "Yes." And that's part of the
Do you have
basis.
anything? No. All right, we're going to have to leave it there.
Yes, Your Honor. I will rest my brief for the remaining issues. No further questions.
Thank you.
Thank you.
Ms. White-Spate.
Good morning. May it please the Court. Hallie White-Spate, Assistant District Attorney for Middlesex on behalf of the Commonwealth. Just to jump in where my brother tagged out, I think the fact that the defendant opens with, she's got a non-prosecution agreement, she could have been charged with assault and battery, but she made this deal with the Commonwealth, and you can take that to say that she's getting a benefit. And then presents her with it and says, "Didn't you make this deal with the Commonwealth?" I don't have the exact testimony in front of me. I think that is sufficient to justify inquiry into the requirement that she testify truthfully. And in any case, my memory, and I can find the transcript site for this, the judge struck that testimony that she was required to testify truthfully. So again, most of the supposed errors that my brother complains of are bits of testimony that were struck from the record. And the fact that the jury acquitted of one of the more serious charges in this case is an indication that they were not so inflamed by all of this supposedly improper testimony, all of which was either relevant and appropriate or was promptly struck or was not heard. I think there was one question where a witness answered a question and no one asked for the testimony to be struck, and it really does appear that that's because nobody heard it. Yeah. Sure.
And I give credit to the trial prosecutor in the candor regarding specifically telling the officers repeatedly, I think is the word she used, about not mentioning probation. And yet the two officers do it.
Yes.
And yes, I know the judge strikes it. But what if we find, based on the prosecutor's comments, that the officers deliberately disobeyed the court order? Then what do we do? Because that should have been the next step, I think, from the defense lawyer, is to ask for voir dire to find out why did these officers deliberately disobey what the judge's ruling was when the prosecutor told them that.
That would be a really serious issue, and honestly, I'm not sure what the next. I mean, I think at that point, a judge would have a more serious question regarding the request for a mistrial. It's still.
Can we find that based on the prosecutor? I mean, again, I give her credit. I specifically told them repeatedly. Those were the words she used. So what do we make of that?
I think in the absence of any actual evidence that they deliberately disobeyed the court order, we are left with, it was struck. The judge who was in the courtroom with the jury, with the witnesses, hearing the evidence come in, is in a far better position than anyone standing here today to decide whether this was sufficiently serious to warrant a mistrial. And even if all three members of this distinguished panel say, if I had been that judge, I would have granted a mistrial on the spot, that is not the standard. I know we're not allowed to say no conscientious judge acting intelligently could have done this anymore. I miss that phrase. But it is still the law that the standard is not that this court might have decided the matter differently.
Can I take you back just for a
Yes,
moment to the examination about the cooperation agreement? Would you agree with me that there is some space between the facts of Rollon and the facts of this case?
I would have to look back at the facts of Rollon, and I admit.
So the sort of key statement there, from my perspective, related to this case, which the end of which is omitted from its quotation in the Commonwealth's brief, is ordinarily questions concerning an agreement's requirement that a cooperating witness give, quote, truthful, close quotes, testimony should be reserved for redirect examination. That's where the quote ends in the brief. The sentence goes on, after cross-examination has attacked the witness's credibility, actually, I think that's where it ends, based on the plea agreement. So my reading of that is that the thing before which you may rehabilitate using the plea agreement is an attack based on the plea agreement. And counsel in this case was very careful to, when the witness was on the stand, to introduce the agreement, to ask the witness to confirm that the agreement was the agreement, authenticate it basically, and not to ask anything about truthfulness. Why does that count?
I think it's clear, the purpose of introducing the agreement is clear, that the agreement itself is an attack on the victim's truthfulness.
Sure, and he uses it to argue in closing, but the Commonwealth can't say, well, later on he attacked her with it, so we could, have the benefit of, perfect vision of the future and rehabilitate her.
I think it does. I think ultimately it doesn't matter because the judge, and I've got it here now, it's volume 2, 216, 217. The judge sustained the objection and struck the testimony about truthfulness. And we presume that the jury followed that instruction. I think there is a potential. I mean, yes, that's a difference, but I think I don't see how if you introduce if you cross-examine the victim by saying you could have been charged with assault and battery. You weren't because you made an agreement with the Commonwealth. Here's the agreement. I don't see how that's not an attack on the victim's credibility. It's certainly, particularly when you've teed that up in your opening by saying she's got every reason to lie because she's got this agreement. I think that's sufficient. It ought to be sufficient. I don't know if there are particular other issues that...
I'd like to go to
yes,
the
please.
impeachment of the defendant.
Okay.
So the judge allows an A and B conviction.
Mm-hmm.
How is that not substantially similar to A and B on a family or household member?
I think it's similar. I think it might be substantially similar. I think that the case law tells us very clearly. Whitman says it. I think Chase says it. Substantial similarity by itself is not sufficient. Is not, it's not the only criterion, and it's not per se error, just because the convictions are similar. The judge.
I assume you don't agree it's reversible error.
No, I don't think it is at all reversible. I mean, I think that there is a temptation in a case like this, particularly where the defendant elects not to testify purportedly based on the ruling to admit the convictions. And I do want to say we have no affidavit from the defendant saying that. The case says you also don't need an offer of proof. It's not fatal. The absence of an offer of proof is not fatal. That's what Little tells us in the footnote. Little also says the absence of an offer of proof saying what you would have testified to definitely counts against you. And this is, I want to remind the court, this is a case where a motion for a new trial was filed, and there was an affidavit from the defendant. And nowhere does the defendant even say, I decided not to testify because these convictions would come in. So even that sort of preliminary fact is not established in the record, and does not say, here's what I would have testified to. And here's why I would have been more credible than the victim. And that being the case, this is not a structural error. This is not something where we get to say, it happened so we just reverse because we don't know what would have come about if he testified. I don't agree that it says you don't need it at all. What Little says, and I don't have the specific language in front of me, what Little says is the absence of an offer of proof is not fatal to the claim. But where you haven't said, where no offer of proof has been made, I mean, there might be cases where, you know, there is something in the nature of the facts of the case that make it obvious what the defendant's testimony might have added. We don't have that here. And Little does go on to say, I mean, this is, you know, again, I confess to not putting the whole sentence in my quote from Roland. What Little goes on to say is the absence is not fatal, but in many cases the absence works to the defendant's detriment.
Well, it says the failure to make such an offer may properly may be construed against him on the questions of prejudice and substantial risk.
Exactly. Exactly. So it counts against him. And the fact that he had every opportunity to do it because he filed a motion for a new trial, didn't raise this issue, I think that's where we're left with this. We don't know. And it's not structural, so it matters that we don't know.
I want to ask you a question about one of your arguments on the same point. As you know, there are sort of three things a judge looks at in deciding whether to admit a prior conviction for impeachment, the third of which is whether other convictions are available. You argue in your brief that there were numerous prior convictions that could have been used. I didn't see, and again, I'm not good at looking for things, but I didn't see a copy of the defendant's criminal history or any listing of additional convictions in our record. Do we have that in our record?
That is, and I am also terrible at finding things, and I'm sure I will not be able. It is in the record appendix somewhere in all these rulings. There's a chart.
The chart that the judge prepared?
There's a table that lists it. No, his Board of Probation record is not there. There is a motion that has a number of docket sheets, and then...
Are you talking about the list that's at pages 79 to 80 of the record appendix?
That sounds like it.
Which I think was prepared by the court.
Yes, that's it. That's it.
The judge did exclude some convictions, right?
Yes, she excluded the violation of a restraining order because at that time it was identical to something that the defendant was charged with. She clearly was aware of the substantial similarity issue because she talks about it in the transcript. So this is not a case where the judge refused to exercise discretion or where she exercised her discretion backwards. I mean, we have that one case where the judge said, well, I have to admit these because they're similar. That's clearly not a mistake that was made here. And so this court, in the absence of an abuse of discretion, has to defer. And then even if it finds an error, has to find prejudice. And the defendant who has the burden to show prejudice simply hasn't done so.
I want to ask you a question about the amendment of the stalking complaint. It's a pretty dorky question, so I apologize, but actually I have two questions. As I read it, the original first stalking complaint had a start date of May 29th, 2020.
I think that's right.
The amended one ended up with the request to amend began on May 21st of 2020, but looking at the docket, the reported date is the 29th?
I think there was one amendment, like very early before the one that sort of consolidated. And I think I have mentioned...
Okay, I can look at that. I remember that on the record.
Yeah, it starts, May 9th is the original start date.
May 9th?
Yes, in the original complaint.
Okay.
At some point, I think that was amended to May 20th, and I'm not sure why that was.
Okay.
I will never find this.
That's all right. I don't want you to take your time looking through the record. People may have questions.
But I think where there was no, I mean, there's no new evidence that the defendant was not on notice of.
I understand that's your argument.
You know, there's certainly no prejudice, particularly where his exposure is reduced. If there are no further questions, I will.
Seeing none, thank you. Thank you both.
Thank
We'll take it under advisement. Proceed with another inordinate pause. What's that? You want me to start singing?
Yeah.
Oh, how are we? Are we good? No further ado. The next case is 22P371 Commonwealth versus Headley. Ms. Horwich.
May it please the Court, Esther Horwich for Mr. Grant Headley. Mr. Headley should be granted a new trial where the judge indicated that there would be consequences if he didn't plea and then exhibited retaliatory behavior against him and defense counsel when he insisted upon a jury trial. The judge's actions crossed the line between being a normal conversation about case resolution to one that was intimidating, both in terms of the timing of the conversation and the words used. The timing was not at the beginning of meeting everybody, seeing if the case could be resolved, but rather was after he resolved a number of motions in limine, was faced with additional motions in limine, and then came out with a number of statements. They weren't geared toward, they weren't requested, a settlement conference wasn't requested by the defense. The statements were not geared toward offering a carrot, but were instead a stick. After these statements, he displayed antagonism toward the defense counsel. Yes?
And I hesitate to use these words, but he was antagonistic toward both sides.
I would tend to disagree with that, Your Honor, and certainly not to the extent that he was with the defense. He was very pleasant with the defense until the defense refused to plea. He volunteered that he would issue a capias. He allowed her motions. He didn't interrupt her. But afterwards, his entire demeanor changed. And with regard to any unpleasantries toward the prosecution, I addressed them in my reply brief, pages 8 through 9, pointing out that one of them, the prosecutor essentially spent 3 pages of arguing that a third-party record should be viewed as a business record of the jail, which was, there's no foundation for that, there's no reason for that, and the judge tolerated 3 pages of back and forth.
Well, he didn't seem to tolerate it particularly cheerfully.
No, he was not cheerful, but he wasn't negative to the extent that he was to defense counsel. And the defendant has a right to an impartial jury. So after making the statements that he did, and I should point out that there were four different statements that he made, and they were directed toward the defendant. He didn't come out and say, this is a charge that offers a maximum of 2.5 years in jail. He said, Mr. Headley is looking at 2.5 years House of Correction on vandalizing, implying that that's what he was looking at if he went to trial, not that it was a maximum.
And that he was looking at possible from and after time, certainly something I'd want to know if I was deciding to plead guilty or not.
Certainly, but that could occur in any situation. And it's one thing for the judge to offer to mention that, but the way he mentioned it and the timing of him mentioning that was inappropriate. He didn't start off the speaking with counsel that way, but it was after he'd gotten through a number of motions in limine and was faced with additional ones that, all right, let's move this along. You know, you're facing on and after time. Once it goes forward, then all bets are off. That sounds very ominous.
But it's
And
true,
if your
isn't
client
it?
is convicted, he's looking at some serious time.
Judge Hershfang had a question.
I'm sorry.
It's okay. It's true that if it goes forward, all bets are off, right? I mean.
Yes, and
you
if he'd offered, say, if he'd made a statement saying, if you accept responsibility, I would assign this. If you go forward, then I won't consider that you've accepted responsibility. But, well, he never offered leniency. He never offered a carrot. It was only a stick. You go forward, you are looking at time. Not this is the maximum sentence, but you are looking at time. And the last thing he said, which was very intimidating, is that there are always consequences that you may not anticipate in these matters if your client is convicted. So that's fairly ominous. And then you look at the totality of the events. You combine them with everything, the change in demeanor, the sharpness, the making mock. I think it's mocking when in open court in front of the client you point out a spelling error. That had nothing to do with the case. But he didn't do it. He did not do it. He did not do it in front of the jury. My understanding is the defendant was not excluded from sidebar. And if I'm wrong, I do apologize, but that was my understanding. He refused to give jury instructions. And the judge has a right to determine what jury instructions, voir dire questioning. Certainly. I'm not saying he violated. In a sense, I am, because the standing order says shall, and
I've never heard this argument before that a district court judge prior to the standing order shall do individual voir dire. That's new to me.
I'm saying that it's based upon the powers and the shall. But even if there was no shall, the way the judge decided to not do those, to not consider some of the request is an abuse of discretion.
Let's talk about whether there was some waiver there. The lawyer files a motion asking for panel voir dire. I agree with you, the judge makes it clear he's not going to do panel voir dire. The lawyer, I believe, never says at that point, well, what about individual lawyer-conducted voir dire? What the judge says is, I'll allow follow-up. And once the questioning starts, he never objects. He never volunteers any questions to ask the veneer. So isn't that a waiver?
I would say not, because the judge only said follow-up questions. This was a new topic. New topics, and she specifically wrote in her motion that she wanted personal views on race and personal views on prisoners who are accused of crime, and she argued that and the importance of that. Exactly, but clearly the judge was aware that those were issues that were important to her, and then he said that she could only ask follow-up questions to what he asked. And those, he did not ask questions involving those issues, and therefore she couldn't respond to them. Well, he indicated that he was not going to do them. I mean, he said, nah, I don't want to get into that. That was the race question, absolutely. And with the prisoner one, he was not going there. So all you're going to do is make the judge angry at that stage. He's already indicated he's not touching it.
What about the racial bias questions? Because this is not a case involving a black defendant and a white victim. And it doesn't fall within the categories that the SJC has outlined where you need to inquire those like interracial rape, murder, or child sex abuse.
That is correct. This is not,
this is a property,
there's no case mandating it.
Property crime.
Yes, but it did involve a takedown by a white officer against a black prisoner. And because of the differences in circumstances, prisoner bias as well, that could impact the racial component of the question. So you essentially have a white guard testifying, and all the video of this, everything that occurred in the cell unit, in the Sally Port, all of that had been destroyed. So it was essentially his word. And the jury should have been, members of the jury who would be biased should have been eliminated from that panel, who might have believed him more because
But I guess perhaps artfully stated, my question is, it's not required.
Yes, it is technically not required, but I'm suggesting in this case it should have been because it was a special circumstance. There's no case that says in this particular series of events it is required, but it does say that the racial question should be allowed in special circumstances.
He did instruct them on implicit bias, though.
After the fact, after they were chosen. But, for example, a jury is asked, can you follow the judge's instructions that the defendant is presumed innocent? And people still raise their hands and say, nope, nope, if he's charged, he's guilty. And those people, we ask that question, and it's a mandatory question, because we know that jurors will not follow directions, and we want to eliminate those jurors. So merely by saying, and in those cases, the judges do give, instructions on proof beyond a reasonable doubt and presumption of innocence. So an instruction won't get rid of a biased juror. We can hope they follow it, but the legislature has mandated that those are questions that have to be asked. And in this case, it's the same theory, but the jury could be biased, and we haven't eliminated those people.
Would your argument be stronger if trial counsel had followed the judge's statement that I'm not going to let you do panel voir dire by saying, then I propose the following 3 questions that the court asked the panel?
Well, I certainly would have preferred it, but the judge did indicate that he wasn't going to allow it. He wasn't going to, it wasn't just, he did say, I'm not going to allow panel voir dire, but she alerted him to the fact that these are the issues that she's concerned about, and the judge did not ask any questions along those lines. So it wasn't that the judge was not alerted that these issues existed. Counsel argued that her concerns, the judge just didn't ask the questions.
The judge specifically addressed the questions that counsel proposed and described why he wasn't going to ask those questions in that way, and the questions had been framed for panel voir dire. So is it your position that the judge then had an obligation to solicit a submission for judicial voir dire on the same topics, or to come up with judicial voir dire? I guess there's a step there that I'm not.
Well, if you look at her motion in limine for individual attorney conducted voir dire, she listed the topics. And in those topics, were personal views on prisoners who are accused of crime and personal views on race, namely views of implicit bias. She wanted that asked in advance. Then that was separate from her proposed questions. And her proposed questions were admittedly rather dorky. But she let the judge know the topics that she was concerned about, and the judge did not ask the questions. But that wasn't all. I mean, I think that's a very serious part, because it's obviously where you choose your jury, where you show the lack of bias.
I have a question about your sufficiency issue. You make an argument that this was super strength glass that was...
I'm sorry, I couldn't hear you.
That the glass was super strength, and you've attached links to YouTube videos showing this type of glass and argue that it was impenetrable and that someone would need to be superhuman to crack this glass. Was any of that evident, any of those claims before the jury, any evidence to that effect, including the videos you've sent to us?
No.
So is it proper to send videos to us that weren't before a jury on a sufficiency question?
I think where the officer testified riot glass, I could do that. I thought about it, and I never said it was evidence.
Excuse me. You can find your own evidence of riot glass and add it to the record on appeal?
I think you can cite to outside sources, but the officer testified that it was riot glass, and I think that needs to be considered by the court. This is not regular glass. You're in a prison. If there were regular glass, there would be breakage all the time.
Okay, we're going to have to leave it there.
All right. Then, in the end, I would just argue the burden is on the prosecution in light of this.
Your time is up.
Thank you very much, and I rest on my brief.
Mr. Lynn.
Good morning, Your Honors. Hold on, I've got a glitch. There we go. Good morning, Your Honors. May it please the Court, Paul Lynn for the Commonwealth. If you look at the record of this case, you see a case in which the judge was brusque to both parties. And while I was reviewing this case for oral argument, I found on page 11 of Volume 3, before the plea discussion, the defense counsel begins arguing her second motion in limine after arguing the first, and the judge interrupts her and says, "Just hold on, counsel, I'll tell you when I want to hear from you." So this was his attitude throughout the trial. There is no evidence that it changes after the plea discussion. And the plea discussion comes, granted, there are these motions in limine, which the judge is very impartial in ruling on. He grants some, he denies some.
Were any of these concerns raised to Judge Somerville, that she thought he was being vindictive or overly harsh to the defendant, or let alone a violation of the Eighth Amendment or the Article 26 of cruel and unusual
Absolutely
punishment?
not. And at the very least, defense counsel could have objected to the judge's involving himself in the plea negotiations. Obviously, a pattern of vindictiveness is hard to pin down, but she certainly could have said this is based on ample case law, that this is not something the courts want. But I point out the case law says that it's not coercion unless the defendant is coerced to do something. So even though the judge engaged in this discussion, the defendant still went to trial. So the next question is whether there's a reasonable likelihood of vindictiveness. And even in those cases, cases like Longville, which my sister cites from the First Circuit, the general remedy for that is resentencing, not a new trial. There we go. And I would especially direct this court's attention to Ravenall, which I cite in my brief, where the court found no reasonable likelihood of vindictiveness where, and I'm quoting now from page 194 of 415 Mass in Ravenall, quote, "The judge told trial counsel that she would impose more severe sentences if the defendant were to be convicted after a trial than if he were to plead guilty, and that after," and there's a big bit of description here, but essentially after trial, and now I'm quoting again, "the judge imposed heavier sentences than those promised if the defendant were to plead guilty." And in that case, in Ravenall, the court found even that was not did not create a reasonable likelihood of vindictiveness. Turning to the voir dire questions, which my sister cites both as a separate issue and as further evidence of vindictiveness, the judge simply did not have to ask these questions. This was a victimless crime, it was a property crime, it was essentially a disorderly conduct in prison. There's no victim here. There's no white victim. It's certainly not the inflammatory situation that exists where you have a black and white rape or a black and white murder. Here you have a case that's not going to incite a lot of passion. There's someone acting out and breaking something. So the judge was clearly within his discretion in refusing to ask these questions, especially as they were phrased by defense counsel. Her question about, again, definitely geared towards attorney-led voir dire, where she's talking about her favorite uncle who said people who are in prison probably belong there. That's certainly a kind of question the judge say, no, I'm not going to ask it in that form. And so that's, first of all, not only a proper decision, but also no evidence of vindictiveness. But regarding the vindictive sentence here, the judge gives the defendant fair warning that he's going to impose his fair sentence based on, and he explains at sentencing, that's because of the defendant's criminal record, his long criminal record. So there's no evidence that this is a vindictive sentence. And regarding the jail credits, if the jail credits are incorrect, the defendant can move to correct that at any time. If he's entitled to this mysterious 18 months, and I have no explanation for the 18 months, but it's important to realize that that 18-month period that the defendant cites is a period that's before his last 2 trials. So this is back 3 convictions. And it's entirely possible that there was jail time credit given for that 18 months at some time. I didn't look that far back at, to try to find the transcripts to find out.
Was he then serving a sentence on a prior conviction?
Was he then?
Yes, during the 18 months.
I think so. He has been in prison for quite some time, but I would really have to check the record for that. But yes, he's been mostly in and out of prison his adult life. So if there are no further questions, I'd be willing to address the sufficiency issue if the court has questions on that, but I am otherwise content to rest on my brief on it. Well, the object, of course, is for the jury not to know that, but of course they're going to know this inevitably in this case. Certainly, the judge would have been well within his discretion in asking a question as to whether or not the jurors would be prejudiced against a prisoner, prejudiced against the credibility of someone who would believe that someone who was in prison was less credible than anyone else. But the judge also had discretion not to ask that question.
But in this case, the judge, my reading of the transcript, never gave a statement of the case, so the jurors had no idea other than the charges. Now, maybe a really adept juror would have been able to figure it out based on the charge.
Right.
But how are the jurors supposed to know whether they have extraneous influences unless a judge tips them off as to what the case is about or asks specific questions about it?
Well, I think if you're right, that that at the time the jurors were selected, they might not have known, again, unless they figured out that this was damage to property in a correctional facility, that he was in prison. But I don't see any reason why a juror wouldn't come forward as they do when a new witness comes in and they say, oh, I knew that witness. They'll bring it to the judge's attention. Oh, I knew this witness in high school, or this witness lives 5 doors down from me. So I don't think there's any reason to believe that if someone was really felt that prisoners had it coming, that they wouldn't say, yeah, now that I see this guy as a prisoner, I don't think I can be fair in this case. The last thing I would like to say before I rest is, my sister cites Sassville for the proposition that the judge has to give a missing evidence instruction if it's requested. Sassville doesn't say that. All the case law says it's discretionary. Most recently, Commonwealth versus Walters, 585 Mass 271, which is 2020. So that's just not true. If defense counsel had asked for either a missing evidence instruction or a standard Bowden instruction, the judge would have been in his discretion to deny it. And the case law is clear. You cannot find ineffectiveness based on failure to ask for a discretionary remedy. And with that, if there are no further questions, I will rest on my brief.
Seeing none, thank you. Thank you both. We're going to take a short recess.
Court is open. Please be seated.
Our next case is 22P648, Johnson versus ASHE. Thank you for setting up ahead of time. Ms. Freed.
Yes. Good morning, Your Honors. May it please the Court. My name is Nancy Freed, and I, along with my partner, Peter Cooperstein, represent the appellant, Julie Johnston. The issue before the Court is whether the trial court judge abused her discretion and/or committed error of law by denying the mother's request to remove the party's twins to the state of Florida, where mother had lived from the time she was 1 year old until she came to Massachusetts in 2005. The parties were never married. They had twin boys born to them on February 26, 2015. The boys were Ryan and Evan. The parties separated when the twins were 3 years old. On November 19th, 2018, amended on December 28th, 2018, the mother filed complaints requesting to relocate to Florida with the 3-year-old twins.
If it's helpful, we've read everything, so we understand the timeline. And with that, let me ask you a housekeeping question. In your docketing statement, you said you had an issue related to the Rule 50, the denial of the Rule 59 motion. There's nothing about it in your brief, and you didn't put the notice of appeal in the appendix. So I just wanted to be clear whether there is an issue relating to the denial of the 59.
May I check with my partner, who actually? No.
Okay, thank you. Go ahead, get right to your argument.
Thank you. Your Honor, what is problematic is that this case has taken 5 years to get through the system, and the children are now 8 years old. The court, as Your Honors know, was required to apply the Giannis test, where a parent was seeking removal. Here, the court found that the mother had been the children's primary caretaker since their birth, which then led to the Giannis test. And the first inquiry was whether there was a good reason for the move or a real advantage. Here, the judge found that the real advantage, and it's listed on page 12 in her rationale, that there was a real advantage to the mother. She does not have any family in Massachusetts. Many of her family members reside in Florida. She's close with her family. The court acknowledged that the lack of familial support in Massachusetts was difficult for the mother. In Tampa, the mother would be near several of her family members, including her parents, who had offered to assist with childcare at no cost. The mother would be able to obtain more spacious housing in Florida. She would have the ability to secure full-time employment, which would result in an increase in her salary, and the childcare would be...
Was there evidence of that?
Pardon?
Was there evidence that she was going to have an increase in her salary?
Mom testified that she had been offered a job at $55,000 in Tampa. She was earning about $45,000 in Massachusetts, because in Massachusetts she was working part-time.
If she worked full-time, though, she was going to make $85,000 here.
If she worked full-time, but she would have child care of some $800 or more a month for each of the children.
That would be shared by the parties?
It would have been taken into account in the child support guidelines. So under the current guideline, where the court, one, attributed full-time income to her, then seemed to back out child care, backed out the child care only for one child at $400 a month, not for two children. So while it is taken into account in the guidelines, the court ordered that she receive $584 a week. She continues to work on a part-time basis so that she can provide the child care, but the economics to the mother between her child support of approximately $30,000 a year and her salary of approximately $47,000 a year make housing, the cost of larger housing.
Okay. I unfairly preempted you. We're good on the first prong. The father is not challenging the judge's finding. There's no cross appeal. So she disagreed with mother on the second prong, so let's get to that.
Yes. So on the second prong, whether the quality of the children's lives would be improved, including the improvement that would flow to the quality of mother's life.
And the interest of each parent.
Pardon?
He has to balance the interest of each parent in considering the best interest of the children.
Yes. And what we argue, Your Honors, is that she did not consider the interests of the mother. She only considered the interest of the father and did not balance those interests. And had she balanced the interests of the mother, we believe that the mother would have been permitted to remove the children.
Her proposed plan cut by more than half father's parenting time and included 12 yearly round trips for 7-year-olds to Florida and back.
In the proposed plan, while it cut the every other weekend schedule, what it did was it added considerable vacation time that would traditionally have been shared by the parties. So for example, traditionally what we would have seen was a rotating holiday schedule, so that perhaps mom would have the February vacation, dad would have the April vacation, that the Christmas vacation would be then annually alternated, that during the summer months there would ordinarily be 2 weeks of vacation for each parent. And in our plan, we propose that the father have the lion's share of all available school vacations.
Did the plan include any detail about the financials vis-a-vis even the air travel?
It did not, and mother was willing to pick that up, which is why she didn't ask for dad to pay it. So,
But her willingness to pick up the cost of airfare was not in the plan.
it was silent. It was silent. It was not a request that father pay it. Mother's plan proposed that mother would be the one to travel back and forth with the children from Tampa to Boston, flights that the children had taken throughout their lives. It's approximately 2.5 hours, probably 5 to 10 flights a day. Mom's parents' home is located maybe 10 minutes from the airport in Tampa, but she had been willing to pay for the transportation. She would come up here and she would stay with friends during the weekend.
What about the disruption of the children's lives and the school and their friends in Cambridge and even the schooling value of Cambridge versus Florida? With the father's testimony, which the judge seemed to credit, that he had now 2 adult daughters who had gone through the Cambridge school system, and he was very familiar with the world-class, as he called it, school system available in Cambridge. And other than mother's opinion that she thought Florida had a better educational system than Cambridge, Massachusetts, wondered, are those not proper considerations for the judge?
At the time, yes. However, there should be recognition that mother is not required to stay in Cambridge. While she is not permitted to leave the Commonwealth with the children, the boys are now 8 years old. They continue to live in an 850-square-foot apartment. They are sharing a bedroom. They are living, when at dad's house, they are in a unit of about the same size. At dad's home, their elderly grandmother, I think she's about 83 years old, is living there. It's 2 bedrooms, 2 baths. The children continue to share 1 bedroom. They were sharing 1 bed with dad at their grandmother's home. They are continuing to live in that space now. And at looking at the best interests, housing that has some more space for 2 now 8-year-old boys would have to be in their best interest.
So as far as you see it, the abuse is that the judge weighed the evidence improperly against mother.
That's correct, Your Honor. By failing to...
That's something we can review on appeal?
If the judge abused her discretion, I think that it...
No, if the abuse is that you wanted her to weigh the evidence differently.
We believe she applied the wrong standard, Judge.
Well, it was Yanis, wasn't it? You told us that already.
But she didn't apply the second prong of the test correctly. It is against the weight of the evidence.
What factual findings on the second prong of Yanis do you say that the judge was in error making, if any?
I'm actually looking. In her factual findings, she lists several factors that indicate that it is in the children's best interest to move to Florida. I'm looking at several of them now. They say the children may benefit from a larger home with more space. If the mother were to relocate, the children would benefit from seeing maternal grandparents frequently. If the mother...
So those are findings you agree with. I'm asking you, what factual findings don't you agree with? Because other than that, it's just a balance.
As I look through them, we agree with the factual findings. However, the judge failed to make findings in her analysis that would have or could have allowed her to make a determination that would have allowed the children to go to Florida. And if the analysis, judge, is looking at the current and not looking at the future, no removal case would ever be permitted. So when you look at how she put weight on the children are thriving, well, the children are thriving in the care of mother. The children would continue to thrive in the care of mother if disruption to the non-custodial parents' visitation schedule was the only factor to be considered, which is ultimately what she looked at, that the children were doing well, and essentially what she found was that disruption to the current parenting schedule would not be in the children's best interest. If that was the test in every removal case, no removal would ever be granted in the Commonwealth because there's always going to be disruption. In the cases that this court has decided in the past, including Giannis, it began there that the children were going to Greece. Clearly, Greece is a much further distance than the children going from Boston to Tampa. Tampa is a pretty easy commute for the children. So going to Utah, going to Wisconsin, all of the cases that have permitted removal have always disrupted a parent's parenting schedule just by necessity. Here, we proposed, we thought was a schedule that we had seen in many other removal cases, which was to ensure that the parent who remained in Massachusetts would have every long weekend, that they would have a disproportionate number of the school vacations. There would be a considerable amount of time in the summer, and it's important to note here that both father and mother are Boston Public School teachers, meaning that father is off from whenever the Boston Public School system gets out to the time that school begins, that there was a considerable period of time that the children could have been in Massachusetts during the summer months.
What is your best case for your argument that we need to reverse this? In other words, your best case that the judge was not acting within her discretion when she ruled as she did?
That essentially the judge did not consider the benefit to the children.
But I mean your best case. Do you have a case where the judge made a similar assessment and then it was reversed?
So I would look at Rosenwasser, which I believe was here a minute ago, Rosenwasser.
It's in your brief, right?
Pardon? Yes, it is in my brief. Rosenthal, a 2001 case, Rosenthal versus Mann, 51 Mass 257, where the court placed a disproportionate emphasis on curtailment of the association with father and his family. And in that case, the court looked and determined that the judge had not properly placed emphasis on the primacy of their relationship with their mother, who had been the primary custodial parent throughout their life.
Do you offer evidence of benefit vis-a-vis, say, a pediatrician or other professional involved that knew the children, or even an expert that illuminated the benefits of going to Florida?
We did not offer the pediatrician. We did offer an expert, Robin Deutsch, who is a well-known expert in this field. She did not conduct, there was no guardian ad litem investigation.
She never met the children.
She did not, and she testified to hypothetical effect on the children based upon the fact she did not meet the parties. There was no investigation. She heard all the testimony, but for about 20 minutes. She reviewed the pleadings and testified how children under the hypothetical would fare given their ages, given their history, given they were well-adjusted. Everyone agreed they were well-adjusted.
Okay, we're gonna have to hold you there. Your time's up.
Oh, thank you. Thank you.
Mr. Harrington.
Good morning, Your Honors. Good morning, Madam and Messrs. Clerks. May it please the Court, Robert J. Harrington for the appellee, Matthew Ashe. The father appellee here is here to request that the Court affirm the judgment dated February 23rd, 2022, and entered by the Middlesex Family and Probate Court. The judgment below was entered based on findings, rationale, and further findings and conclusions of law made by the trial judge in quite an extensive manner. The trial judge correctly identified the evidence before it, including 106 trial exhibits, a stipulation of uncontested facts, and the testimony of 8 witnesses, being the mother, the mother's mother, the maternal grandmother, the maternal grandfather, the father, the paternal grandmother, the 2 daughters of the father's brother, and the expert designated by the mother, Dr. Deutsch. Picking up on a question that Your Honor just asked, Dr. Deutsch did not offer any firsthand expert opinion about anything in this case. She had no contact or knowledge of any of the parties. The judge,
is that atypical?
well, it's atypical if she's going to testify what the benefits to these particular children are for a move to Florida if she doesn't even know anything about them other than what she heard at trial. And the judge acknowledged Dr. Deutsch's expertise, acknowledged that she gave guidance in certain areas, but well within her discretion limited the weight she was going to give Dr. Deutsch's testimony. There were several factual assertions made during my sister's argument, and I won't refute them, but I would point to the court's attention the idea that she could work full-time if she moved to Florida, that she would get an increased salary, that there wouldn't be less time for the father in parenting if the move to Florida was allowed, that the cost of child care was $800 a month per child, and that the mother offered to pay for the travel associated with the parenting plan for a move to Florida. I don't believe any of those are supported by the evidence, in fact, contradicted by the evidence and found otherwise by the judge in weighing all the evidence.
Do you take the position that expert testimony was required before the judge could rule that it would be in the children's best interest to relocate?
Absolutely not.
Okay. Was there testimony that you maintain was missing on that topic?
I think I think there was lots. The brief argues, the appellant's brief argues about several areas of error committed by the judge, trial judge, in her failure to make certain findings. But I assert that that criticism is very well misplaced, because the judge ruled or found in accordance with the evidence she was presented. For example, on the issue of the benefit to the children from a move, the judge acknowledged that a larger house would be a benefit, that the proximity to mother's family would be a benefit, and nothing else, because that was all the evidence she was provided. The mother repeatedly testified, whether it was in response to what Florida would offer that Massachusetts couldn't, or what made the mother unhappy here, or what benefit would be to the children. The only three things she talked about were a bigger house, proximity to her family, and the ability to work full-time, which the trial judge correctly knocked down as a potential benefit for the children, because trial judge found that she could and would be able to work full-time here at a much higher salary than she could ever earn in Florida. And continuing on that topic, there's a section in the appellant's brief that talks about the judge's failure to take into consideration the benefit that a shorter commute would have on for the mother would have on the children. But I asked the court to consider that a red herring. The mother's commute probably would have been a little shorter in Florida, but the testimony was that the children would be taken care of after school by the grandmother. So whether the mother had a shorter or longer commute offered no benefit to the children. Furthermore, there was no evidence about what school the children would attend, what the school schedule would be for them, what her potential work schedule would be. So there was no way the trial court could evaluate whether a shorter commute conferred a benefit or would confer a benefit on the children. The other thing I'd like to respond to was the commentary my sister made about my client's living arrangements, both at the time of the trial and now. In the transcript, he's asked about where he lives and testified that it was not ideal for a 50-year-old man to be living in a two-bedroom with his mother. But there was a reason for that, and the reason is spelled out in the evidence and in the financial information that was provided by the court. He didn't have another option at the time. He's a joint owner of the property where the mother appellant lives with the children, but he has no access to it. He can't live there. So his considerable part of his net worth is tied up in an apartment that he can't get access to those funds. He testified, and the judge attributed his testimony as credible, that he would get other arrangements once this case was decided and he could get his money from the condo in Cambridge. And finally, I'd say this case is really about trial strategy. The mother chose to put in the evidence she wanted at trial. Most of it was focused on the father being a bad guy, not a suitable parent, lived at his mother's house, things of that nature. The father's mother wasn't capable of providing any benefit because she slapped one of the children once. But she did not provide evidence that she admits the trial judge would have needed to support a decision to remove the children. There was no testimony, remarkably, that the mother ever did anything with the children. That there's not one bit of testimony that the mother enjoyed spending time with the children. Why? What made her happy about that? What made them happy about that? So if the court has any further questions, I'm happy to answer them. Sorry.
Seeing none, thank you. Thank you both. We'll take it under advisement. The next case is 22P 1180. It is also impounded. Department of Children and Families versus Mother.
Good morning, and if it
Wait
please
for everyone to sit down. Mr. Papirio.
Good morning, if it please the court. Mark Papirio, representing the mother in this case. I wanted to go directly to the question of the potential waiver of the discovery issue. And I suggest a close reading of the transcript. There's just a 10-page interaction, transcript 19 to 29, suggests that this issue is still before the court. And I wanted to walk quickly through what happened there. Bless you. The mother's attorney withdraws. She has some family medical issues. And then the issue of access to the department's file comes up. And mom's just former attorney attempts to allay any of the judge's fears and explain why that would not be a problem. And the judge interrupts and says, "Thank you. I've allowed your motion to withdraw." And then we hear from child's counsel who says, this child, who says, "I'm concerned. There might be, some private matters I don't want out there." And then the other children's counsel pipes up and says, we don't know whether these other children are learning virtually or in person. And if they're learning virtually at this point in time, I think mom's going to have a problem getting to the courthouse. So the judge inquires of mom a few moments later about this, but that was not a question as to, are you going to be able to get to the courthouse? It was, are you going to be teaching these children virtually, or are they going to be in school in person? And she says, virtually, it'll be a challenge and a half, but okay. That was my choice. And I suggest to the court she's taking it on herself.
But then, hold on, you sort of missed another part. But then doesn't the judge also say, and if there are any issues, let me know and we'll figure something out?
I'm going to come up to that, Your Honor. But before we get there, mom is sort of taking it upon herself, saying, well, I chose virtually. I suppose I could, in my view, I suppose I could take the hit, on this. She's sort of going along to get along. And then the judge says, well, are you going to be able to get down here to review the file? But she doesn't let mom answer that question. She just forges ahead, doesn't wait for an answer, and says, here's what I'm going to do. The file will be available to you in the clerk's office.
Does the mother ever object to that? And standby counsel is there, right?
Standby counsel was not there, Your Honor. Standby counsel was appointed that day.
Did mother object?
Okay. Well, she does not object at that point, but then there's
she didn't make a due process argument.
Well, I'm making one now, Your Honor. I think the issue is still before the court. And what Justice DeAngelo just mentioned, then the judge promises her.
All right, I'm sorry. I'm a procedure guy. Can you help me out with some case law that says that we get to reach a constitutional issue that wasn't raised at trial in a civil case?
Your Honor, I think it was raised. Just as I had mentioned a moment ago, just dismissed counsel.
I thought her concern wasn't that she could get to the courthouse.
It was that there was no reason not to provide mother with a physical paper copy of the file.
Well, the parties did raise concerns to that very fact, but including the child.
They did. But mother's counsel, or mother's ex-counsel, if you will, was not given a chance to finish what she was about to say.
Well, she wasn't representing her anymore.
That's right.
Didn't the judge also explain if you had counsel?
Yes.
This wouldn't be an issue for you.
Okay, but that's not an excuse, if you will, for not following through on allowing mother access to the file. So she makes this promise. So, you know, and if you find out the file's too voluminous or you can't get up here or something's going wrong, just let me know and I'll look at it again. And so this is...
Does the mother ever do that?
Yes. In April, we come back. That's the next place we are, Your Honor. And there's a pretrial conference, and they're talking about it, and she says, well, you know, what's going on, and Mom, have you been able to get up here? And the mother says, well, yes, once for an hour, maybe two. And this is what Justice Meade was just talking about, but I see it from a different viewpoint. She's saying, you know, if you had counsel, these problems would go away. But it's clear that mother is not going to accept counsel, and this is why there's no argument before you.
Counsel, I'm going to back up again one step. After the judge says, have you been able to come and look at the discovery? Yeah, I've been able to once. Does she raise any objection to the procedure that's in place at that point?
No, it's just that I'm not being able to get down here. So then the court...
Have you identified any, if she had had proper access, as you say, what she missed out on, who the witnesses she would have treated differently, the documents she would have offered, new areas of cross-examination, and you don't have any of that?
Well, Your Honor, what we have is, moving to the harm issue, standby counsel made a couple of objections. Most of them were overruled, or the evidence was taken to Benny. But there are 1,200 pages of exhibits here that came in with almost nothing limited. And I can see that the department says, well, you know, you didn't point to anything. But in the department's brief, they discuss at length some I see at least one issue specifically. They discuss visitation supervisors and saying, oh, look at these things that mom is doing at visitation. And that's, you know, that's she's creating a harm to this child. And those, I think, were inadmissible hearsay. And I would distinguish the Rule 23 opinion that she has here that talks about lack of harm. It wasn't the same situation here. The mother was represented by counsel in that case, and they didn't really, they said, well, your attorney was there to protect your rights. That's not what was going on here.
Are you asking us to apply a different standard because this mother was self-represented?
Not a different standard, Your Honor. I think what I was getting to when we moved on to the harm issue was the trial judge wanted to talk about access, and she says, so wait a minute, the clerk's office is making sure that they give you time, aren't they? And she said, oh yes, it's not that the clerk is not making the file available. But access wasn't the question here. It was her need to have the physical file. The deprivation was her not having the time to get there. And then when you mentioned, Justice Hershfang, a minute ago about did she ever object to that, I wanted to make another point. In the supplemental transcript, the child says, well, she had another chance, too, in June, and I would take issue with that. First, that was not a status or a pretrial hearing. That was the probation department advanced the case, and the issue there is, what happens there is they notify everybody that they're bringing the case forward, you know, hope to see you. It's
Counsel,
sort of
I'm failing to find in the record and what you're saying any place where the mom told the judge, I'm having a problem seeing the file. I mean, if it had been something of, I only been able to go once and I can't get here more often, well, then the judge is on notice. But there's nothing like that. So not only isn't there an objection, she didn't even voice a real concern to the judge. How is the judge supposed to know there's a problem unless it's told to the judge?
Well, I think in the October, in the first discussion of it, Your Honor, there is mention of mom is going to have a real problem, by the other child's counsel, mom's going to have a real problem here if she's teaching these children virtually. And then, it's discovered she is teaching these children virtually. She's going to have a challenge and a half, she calls it. And then we hear again, well, I'm having problems getting up. Well, I don't know if those are the exact words, but I've only been able to get up there once for an hour or two. I think that those two things combined put the issue before this court.
I mean, the challenge of your argument, and I don't say this at all to diminish the importance to the mother in this incredibly intimate and, important decision in her life, and having experienced counsel to guide her way. But it sounds to me as if what you're saying is the mother didn't make these objections and didn't raise these concerns, in essence, because she didn't really have the background to know what she was missing. If she had had counsel, she would have understood what it means to review discovery and the importance of making the time and also having the background to be able to understand what it is she's looking at. And so you, appeals court, shouldn't hold her responsible for not having voiced those concerns and made those objections, because she didn't really have the wise counsel that she needed in order to know that that's what she had to do. And if that's true, I'm sure it's true that she didn't have the wise counsel, because, at least early on, she didn't even have standby counsel. But I'm also not familiar with any case that requires or allows us to make that extra leap, that she was basically deprived of the assistance of counsel and therefore is entitled to a new shot.
Well, I don't think it's that, Your Honor. I hate to sound like a broken record here, but I'm saying I think that the two things did put the issue before the court, and that there was harm that stemmed from that, that the last hearing in June was not a status hearing. In fact, it was over, and the judge said, somebody asked a question about deadlines, and the judge says, hey, if anybody else has any problems, let me know, file a motion. It wasn't saying, is there anything going on right now that you're having trouble with? And she was still struggling with preparation a week before trial when they had a hearing there, and for other reasons, the case got continued for another week. So before I move on from this issue, I wanted to distinguish the 128 decision, Igor, that's cited by the department. And I think in that case, the mother was offered her own copy of the physical file and just never bothered to show up and pick it up. Also, of course, the panel knows they're not bound by that. It's because of the nature of the decision. And also importantly, Igor was decided pre-pandemic. One of the things hanging over us here is the virtual learning and all of that stuff. Getting to court was an issue. Most of these proceedings were on Zoom. And in the transcript, you see a lot of can't understand, inaudible because of the nature of of how the trial was conducted. So I also wanted to quickly mention a couple of things. I state in the brief several findings that I have issue with, but I think I only have time. I wanted to talk about the most important one for the mother's case was the court's finding that she inflicted physical abuse on the child. She made marks on the child's back, harmed her, supposedly with the intention of drawing attention to her belief that the child was sexually abused, and I don't think that that's fairly made. I think it was speculation on the part of the physician, and she ignores testimony from the maternal grandmother who says, look, I was with her from the moment we picked this child up until the marks were discovered. And child's counsel suggests that she was not a credible witness because there's another fact, she had her days wrong, but but the court in another area of the brief and another area of the findings credits maternal grandmother on another topic. And so I think it's not just that she did not find this witness credible, she completely ignored her. And I would suggest in the final portion of the argument that without the finding of physical abuse, the department did not meet their burden in this case. They had, the only thing that I found is there's a suggestion in a 128 decision or a Rule 23 decision pointed out by the department that unnecessary medical exams may be evidence of harm. But other than that, I would suggest the department hasn't met their burden. I would ask the panel to remand and order a new trial. Thank you.
Ms. Parr.
Good morning or afternoon, Your Honors. Kim Parr for the Department of Children and Families. Would you prefer if I start on unfitness or the discovery issue?
Your choice.
Okay. I will speak briefly on unfitness. As to Mother's Counsel's commentary about the finding on the marks, I do want to make clear that in that finding, the judge did not rely on this emergency room physician's statement that is charged as being speculation. The rationale for the court's finding rested more than anything in the credibility determinations that the judge drew about the witnesses. The judge heard Mother's testimony to her belief that the marks were round with a pinprint caused by injections. The mother heard the judge heard the maternal grandmother's testimony, not that she was with mother and child nonstop over the subject period of time, but that she was there to help with transportation. And so the judge, hearing all of this testimony, listening to it, looking through the evidence, made a very small leap to say, here we have a mother who is so committed to these unfounded suspicions of sexual abuse that she disobeyed a probate court order, refusing to turn the child over for visitation. When the child, she ended up in jail, I think, for 2 hours or so. When the child was returned to her, the mother immediately thought to examine the then 2-year-old's vagina, believed that she found evidence of harm, went to another physician, a new one, not the ones she'd seen in April. That physician didn't substantiate her claims. And so that is the rationale the judge provided for believing that it was more likely than not when mother went home, she took the unfortunate step of causing those marks on the child so that she could substantiate the claims to yet another doctor on the next day.
Where in the record should we look for evidence of the harm to the child from the mother's behaviors, acknowledging that the behaviors are well documented in the record, that they certainly seem to evidence some mental condition on the part of the mother? Where is the harm to the daughter?
The harm to the daughter is most apparent in the visit records, and you'll find there's 10 conclusions of law and the introduction where the judge is referring to the more current conduct of the persistent genital exams, the questioning, and that is the source of the harm. So I can give some examples of after the child was removed from mother's care, she engaged in this pattern of behavior that went far beyond a concerned parent. Mother checks the child's body and back at virtually every visit, even when the child protests and there's no specific cause. If you'd like it, I can give the site. It's E1191. E1027, mother, and I think this gets to your point most directly, Your Honor. Mother excessively cleans the child's vagina during diaper changes, and there's evidence of the child audibly exclaiming, ouch, during one 10-minute diaper change. The child protests, kicks, and screams during other diaper changes. Mother admitted to physically opening the child's vaginal opening at one point and reporting it as being red and open. And as for, all of that speaks to the potential for additional physical harm in terms of taking it a step further than the marks that were on the back. And though the judge didn't reach this or say it directly, the implication is the emotional harm as well. And part of that is seen was in father's testimony, which the judge credited that he has a difficult time, or the child has a difficult time going to visits and hesitates going into the room. Looking at the record as a whole, yes, the child eventually settles once she gets into the visitation room, but the record makes clear that tempers flare and things really change around diapering and bathroom breaks when mother keeps pushing on those and the child has vocal and sometimes physical reactions, kicking, screaming, running away. And all of that shows the harm to the child. And up against it, we have evidence that mother has not gained any insight over the 2+ years of the petition about what she's doing. She refused to participate in a psychological evaluation, which would have provided important information to her and to the department about what might be going on with her mental state. She attended therapy for about 12 or 13 months. The social worker testified that he never got information from the therapist that mother had made any progress in dealing with her fixation about the sexual abuse claims. She just, it seemed like, kept reiterating them. And the record shows she didn't, because a lot of the troubling behaviors that occurred during visits happened during and after she was at therapy. So on this record, the judge reasonably concluded that unless and until mother takes some action to address her mental health struggles, she's not fit to parent the child, and that should be affirmed. On there, I'll just note this isn't a termination case, so mother still has the right to review and redetermination. She has a right to visits, and the focus is on, at that moment in time, she was not fit to parent the child. Briefly on the discovery due process argument, the record of the October 29th, 2020 conference speaks for itself. The judge very expressly gave the mother options. Would you like to come to the clerk's office and look at this, or would you like to take them home?
Can I ask you about that in and of itself?
Yes.
Why should there be any restriction at all put on a self-represented litigant? She steps into the shoes as if she was a lawyer, in a sense. Why should there be any restrictions whatsoever? There was no specific finding by the judge that that was required. There was no specific, in fact, I believe the lawyer for the department said nothing specific. So why was that permissible in and of itself?
All of this is in the context of seeking the best interests of the child, and there is a department regulation cited in children's brief, 110 CMR 12.09, that governs the release of DCF information and gives the department the authority or the option of bringing issues to the judge's attention if they think releasing information will not be in the child's best interests. And that was the gist of what was happening here. The department raised it as a concern, possibly given the history of mother's involvement in the case. By that point in time, she had contacted a television show about administering a lie detector test. She later testified to posting information online. So though it's not directly said in that October 2020 transcript, the environment seems to be, and was said by Children's Counsel, we're concerned about the privacy, we're concerned about the contents. And mother was only unrepresented for 6 months. Then standby counsel came on.
I have to hold you there. Thank you very much.
Your honors.
Ms. Mercier.
Good afternoon. May it please the court, Amy Perry Mercier on behalf of the child. The trial court was within its realm with regard to restricting access to the DCF file. Massachusetts regulation 110 CMR 12.09 says that DCF has to release the file. However, if they have concerns, they have to bring it to the attention of the court, which was what was done appropriately. Given the situation with regard to the judge's experience with the mother in this case, and the sensitive nature of the information, especially with regard to the allegations of sexual abuse, that's the reason that child's counsel brought it to the court's attention that they would like restricted access.
I don't understand that.
Sure.
There was not restricted access in the sense that mom could review everything, could read everything.
Correct.
So there was no protective order to say, Mom, you're not to disclose anything to the public. All it was you can't have the file, you have to come and read it at the court.
Correct.
How is that restricting access to the file?
I think that when you're counsel for any of the parties in a care and protection, typically discovery is given to counsel. With the standard juvenile court orders that it's not to be disseminated, that you have to destroy it, all of those protections. When you are giving that to a pro se litigant, then, you would have to, it's harder to control that because generally in Berkshire County, we're a small bar, there's about 15 or 20 attorneys that are constantly before the court. So it is important, I think, for child's protection, just in case mother happens to put it on the internet.
But the judge could have taken a step before that. Again, my question is, I understand the department regulation about restriction. There was no restriction here. It was just go from one location to another. Shouldn't there be a step before that saying, I'm going to give you the file, but I'm ordering you not to disseminate it, just like a lawyer would have?
I think that the facts of the case involving various posts on social media led the judge to make that decision. And the judge has authority to make those decisions with regard to discovery and to control discovery. Absent an abuse of discretion.
And I'm asking you why this isn't an abuse of discretion. The judge is treating the pro se litigant differently than a lawyer, as you just said,
Correct.
Without any finding that I could find that permits that.
There was no finding other than what was said at that time. But I would say again that the issue was not preserved. So the judge necessarily wouldn't have to make a finding because there was no objection before her. With regard to it. When explained how mother could access the full DCF file, she said, I understand the concerns regarding the privacy of her child. So she never specifically said, I'm objecting, I want the full file. She there was a back and forth, and I apologize, I was trial counsel, so I'm reliving it. But there was back and forth with regard to how this was going to work, and the judge continually gave mom the ability to object and the ability to say, this isn't working for me, and the judge very kept saying to mom, you need counsel. This is a complicated issue. You would be better served by having counsel. It wasn't at the end when her prior counsel withdrew, you can't have counsel anymore. This is your fourth attorney. It was, you can still have counsel. It is in your best interest to have counsel. And the judge really, given the sensitive nature, bent over backwards for mother to make sure that she was prepared. And any time we were before the court, it was, is there anything else? Is there anything else that needs to be brought forward? And mom never brought forward, this is a problem. I don't have access to the file. Even on the morning of counsel, or the morning of trial, excuse me, when mom was there on the phone, she objected to going forward, but not because she didn't have access or time to prepare. She was saying she was having personal problems at that point. So it had really nothing to do with anything to do with her due process rights or her access to the discovery. And even then, and I know it's off the, it is not within the record itself, but upon the standby counsel being appointed, it's at that point, the transcript, or sorry, in the transcript it's noted as well as within just that standby counsel did have access to the file and to all the exhibits prior to trial. And even standby counsel didn't object at the time of trial that there was an inadequate access to the discovery. And I would also reiterate that, you know, mother continues to have the right to review and redetermination in this case. It's beyond 6 months. She could bring this forward at any time and ask for another finding of fitness or unfitness, or to ask for the child. And so as a result, I would ask that this court affirm the lower court's decision unless there's any other questions.
Seeing none, thank you.
Thank you.
Mr. Vincelette, you have 1 minute. No one will accuse you of being greedy.
Good afternoon, Your Honors. May it please the court, Attorney Vincelette for the father in this case. With my brief time before the court, I'd just like to touch upon what I feel is the main issue in this, and that is that the mother in this case never made an objection to this, the discovery ruling by the court. She had from October 29th, 2020, all the way up and including the day of trial, July 21st, 2021, which approximately 9 months, to voice her objection to this. She had standby counsel who could have filed a motion to reconsider the court's
That wasn't
ruling
standby counsel's role, was it?
Judge, it wasn't unless the mother expressed to the standby counsel that she was having an issue.
So standby counsel on his or her own couldn't do that?
On their own, they couldn't, correct. But certainly if mother was having access problems with this discovery, it would be presumed she would have shared that with counsel. Again, no objections were made, and we're asking the court to affirm the lower court's decision.
Thank you. Thank you all. We'll take this under advisement. I'm going to call it the Carter pause. Okay, yeah. All right.
Slap it upside the head.
Just let me know when you're ready.
That seems like a flaw.
We're having a technical problem. Just bear with us. The computer took a lunch break.
I envy it. I envy it. Why don't we have snacks up here?
No? Oh. AJ, did you contact Matt?
Yeah.
Oh, all right. Oh, thank you. All set? Thank you, Matt. Our next case is 22P630, Boston Capital Funding versus BEK Winchester Winning Farm. Ms. Slaughter.
Good afternoon, Your Honors. May it please the Court, Shannon Slaughter for the appellant, Boston Capital Funding. Since Your Honors have indicated you've read the briefs, I'll get right to the arguments in the case. The Superior Court's summary judgment decision was an error of law for a number of reasons. The first being that it applied the Tristram's Landing factors and the rules set forth by the SJC in that case. However, after the summary judgment decision was issued, the appeals court came down with the Huang case that distinguished the Tristram's Landing case, essentially for the reasons that I argued to the Superior Court. The Tristram's Landing case, number one, did not contain an exclusive grant for brokerage for the sale of property. It applies, this SJC specifically stated, when a seller is looking for a purchaser of property. Those circumstances are not involved here. We have a broker who is engaged to procure equity for the development of a property and the purchase of land for that development. This is similar to the buyer agreement. In the Huang case, the court says that for that buyer's agreement, the homeowners and the sellers there engaged the broker to procure a new home. That is analogous to the procurement of equity in this case.
If the Novaya funding was not equity, should your client lose?
I don't think so, Your Honor, because the breach occurred well before the Novaya funding was actually procured. The breach occurred the second the contract was signed, because the grant of exclusivity to raise and to procure that equity funding, it was breached the second the Boston Capital Funding agreement was signed.
But there are no damages at that point. So while you might arguably have a breach floating in the ether, you don't actually have a case.
Understood, Your Honor. But I think that whether the Novaya funding is equity is really a question of fact. I don't think that that can be decided on summary judgment. But if it is determined after trial to determine whether the Novaya funding constituted equity or debt, or probably a combination of both is what a mezz loan is, that's something that has to happen at trial. It can't happen on summary judgment.
What factors or facts can you point to, other than the word exclusive, that this was exclusive? Because that's not enough.
You mean what obligations did Boston Capital Funding have? Yes, the agreement itself was to procure equity. These are two sophisticated developers. They both know what is required to procure equity. But if you look at the agreement itself, and I'm sorry, Your Honors. The first copy of it is in the Record Appendix, Volume 1 at page 31. It requires that Boston Capital Funding deem potential investors, look at the language for you, fit by the broker consultant. So they have to identify and deem certain people fit and then provide them the personal and financial information that is set forth in the agreement right after the bullet point number 1, that's in bold. So it has to go out and deem people fit and then give them this financial information. These are two sophisticated brokers. They know what procuring equity is. But I would say to Your Honor that the Tristram's Landing line of cases that apply to the sale of property, not purchasing property, none of those cases involve submission of a retainer. What we have here is submission of $2,500 retainer fee. What the Tristram's Landing and the SJC that affirmed the Huang holding and what the appeals court said in Huang was we look to whether there can be revocation of the agreement prior to any ultimate consummation of a transaction. And here, there's submission of a retainer. The submission of a retainer was to ensure that procurement services would be performed. Those procurement services were performed by my client, but the only reason that the transaction wasn't consummated with my client's efforts was because of the breach. So
what record evidence is there that your client had other sources of funding ready and willing to provide funding.
Your Honor, that's not, I would argue, that's not the standard. That's the Tristram's Landing standard. My client doesn't have to show that he had people ready, willing, and able to invest. He just has to show that he exerted some sort of efforts. He did have 6 potential investors that he brought to the property. He exerted efforts. There's an affidavit from him in the record to that effect. But we don't get to, was there a ready, willing, and able buyer procured by my client, because that's the Tristram's Landing factors. We look at the Huang case, where in that case, the broker was also not the predominating cause. She didn't have a property ready, that the clients were ready, willing, and able to buy, but she was still entitled to a commission in that case. Well, not a commission, expectation damages.
She was entitled to further proceedings to determine whether there were any damages.
And that, Your Honor, is because that agreement was an oral agreement. Here, we have in writing what the expectation damages are, 3% of the funding that was ultimately procured. And we know what that is. We know what these parties expected because it's in the agreement.
Well, I mean, the Huang case, I'm glad it's not true, but it's certainly not true that we can overrule or change the law that's established by the Supreme Judicial Court. So as great as that decision may be, there's no, and I don't think you're arguing that the Huang case overrules Tristram's Landing.
No, Your Honor. The SJC explicitly states why it is distinguishing from the Tristram's Landing case, because there is no exclusivity in Tristram's Landing. And I again argue to Your Honors that here we have circumstances that are outside the scope of all of these brokerage cases, because I'm not aware of one that involves the payment of a retainer to secure the services, to entice my client to provide those procurement services, to deem people fit and give them the financial documentation that is contemplated in the Boston Capital Funding Agreement.
The affidavit that you referenced that people had already been contacted by BCF, was that submitted in the motion for summary judgment?
Yes, Your Honor. And I believe there's, I'm not quite sure if the testimony from my client, Kevin Hearn's deposition, is in the summary judgment record. I'd have to look that up. But all of the summary judgment exhibits are in this record. So if they were submitted, the testimony was submitted, it's in there. And Kevin Hearn's deposition, I'm sorry, I don't have it at my fingertips, but it does say that he did exert efforts to procure potential investors. Admittedly, none of them were ready, willing, and able, but we don't get to that point, is what my argument is.
If we find that the agreement was exclusive, aren't the damages governed solely by the retainer clause?
They're not, Your Honor. The
Why not?
retainer, I will refer to the cases that are cited in my brief. The retainer fee is not a liquidated damages clause. It's that's the consideration to retain the services, but it is not limiting to the $2,500 retainer fee as liquidated damages. I refer to, I don't have them on the top of my head, but because that was sort of a additional argument, but the case law in my brief on that point, Your Honors.
I hear you. I hear that argument. The piece that doesn't seem to me to flow directly from it, and I'm hoping you can explain this to me, is why, if your client, let's say we agreed with you hypothetically about your, contract of good faith and fair dealing argument, why is the proper measure of damages for your client that your client receives a percentage of the amount procured by someone else?
That's what the SJC held in the Huang case that was just decided in February of this year after our briefs were filed, but that it's the expectation damages, Your Honors. And the expectation damages are set forth. What the parties expected from the fruits of this contract was 3% of the equity procured. The equity procured here, it's undisputed, was the $4 million from Novaya. There's also testimony in the record from Mr. Cates, who states that initially what the parties expected was procurement of $3 million of equity. So ultimately, the parties did intend for whatever was ultimately procured for equity, 3% of that procurement is what the expectation damages are. And to the extent that there's any dispute about the amount of the expectation damages, that's a dispute of fact that is more appropriate for a jury than for a summary judgment decision. And Your Honors, if I would just turn to the 93A argument, because I think it's important in this case. The breach of contract claim was not the only issue here. The Superior Court also erred in ruling against my client for his 93A claim and also the breach of covenant of good faith and fair dealing claim. Mr. Cates knew exactly what he was doing when he signed this agreement with Boston Capital Funding. He had a seller telling him they want evidence right away that they have the ability to close on this property. Mr. Cates, what he first did was he went to Newmark, asked them to lie, asked them to say, we have $1.5 million of equity commitments in hand right now, and we're confident that we'll get the $2 million equity commitments by the end of April. That wasn't true. The second thing he went and did was he reached out to Boston Capital Funding, told them he was granting them the exclusive right to raise this equity, knowing full well he was already under contract with Newmark to do that exact same task. Admittedly, the Newmark authorization and grant was broader. They were allowed to raise debt and equity, but that grant of equity to Boston Capital Funding had already been granted to Newmark. Mr. Cates testified that he has entered into these brokerage agreements hundreds of times. He knows what the word exclusive means. He knows that parties like Mr. Hearn and Boston Capital Funding, who are these types of brokers, exert a significant amount of energy. This would have been almost a third of what Mr. Hearn would have earned for that entire year, and he spent this energy based on Mr. Cates' word that he had the exclusive right to do so. Boston Capital Funding would not have gotten into a David versus Goliath battle with Newmark Knight Frank, which has many, many more resources. He testified, it's in his affidavit, he'd done that before, he'd gotten burned before, and he had a policy of not entering into these agreements unless they were exclusive. And he relied on that exclusivity in moving forward with this agreement.
He drafted, by he, I mean your client, drafted this agreement, is that right?
He drafted the initial draft, and then Mr. Cates he changed terms. He renegotiated certain terms of the contract, gave it back to Mr. Hearn. He said he did not focus on the term exclusivity. He changed. Mr. Cates. My client drafted the initial form. Mr. Cates looked at it. He made changes to it. He changed the amount of the percentage. They call them points in this industry, but he changed the points. He changed the triggering event for when a commission is earned. But he said he didn't focus on exclusivity. That's simply disingenuous, Your Honor.
Do you agree that your contract contains no specific consideration from your client about the efforts that he is undertaking to make as a result of the exclusivity portion of the agreement? In other words, not that he's going to make best efforts to place the equity, not that he's going to undertake any enumerated tasks?
Your Honor, I agree that there's no standard of his efforts specified and that there's not a laundry list of what those efforts are to be.
Or even like one sock of the efforts, to use your
He has to deem potential investors fit. That is in the agreement. And then he can provide them with the financial information. So that obligation to do that, and in general, the obligation to procure equity is what the contract is all about. It's an engagement agreement to procure equity, and that engagement, those services to deem people fit to procure that equity, was secured by monetary consideration. If you look at the cases that involve unilateral agreements, those focus on the sellers not providing any consideration. Here, if you're using that analogy, the seller, in this case, the principal, is BEK and Mr. Cates. There was consideration provided by BEK and Mr. Cates. It was a $2,500 check that my client had to maintain in escrow. There's obligations in here that he maintains it. He has to apply it to any ultimate commission. He has to return it in certain circumstances, and it gets forfeited to him in certain circumstances. So there are obligations. Would I have wanted them to be more enunciated? Absolutely. But there are obligations on my client's part in the engagement agreement, Your Honor.
Counsel, this may be a side issue, but I just want to make sure we address it. Is your appeal from the dissolving of the appeal bond order before us?
Yes, I believe it is, Your Honor.
Why isn't it moot?
Your Honor, I think that this could be remanded and that a new order could be issued to require a resubmission of the bond or a reissuance of the attachment that was granted by the first judge in this case. So I don't believe that it's moot.
Okay.
Thank you.
Thank you.
Mr. Joyce.
Good afternoon, Your Honor. Richard Joyce from Newman & Newman for the defendants, BEK, Winning Farms, and Eric Cates, excuse me. First and foremost, I think what's not really discussed here, the appellant seems to lump together the two defendants. I'm not certain why that is the case. This is a clear contract that was between two corporate entities. The individual here is not a party to the contract. It's clear that it was signed by an agent of the principal. Boston Capital Funding's brief assumes exclusivity. That's a mistake. Just as Justice mentioned during my sister's argument, just because the word appears there does not mean that it is in fact exclusive. It is no different, in procurement of equity, is no different than get me an orange. There's no exclusivity. You look at the Samuel Nichols case, which is probably the most detailed on that. And in consideration of your listing for sale and to undertake a finding of purchaser, bilateral agreement. Here, we don't have a bilateral agreement. My sister is confused on her argument with respect to the retainer. The retainer was consideration flowing from my client. There was no consideration flowing from her client. That's the problem here. We have the word exclusive, and we know from the case law that that is not sufficient. You cannot be a passive recipient of a grant of exclusivity. And this one-page agreement does not list the efforts that Boston Capital Funding has to undertake. Now, Boston Capital Funding has the right to undertake those things. And again, in my example, if they want to get that orange and deliver that orange to me before I say, no, I don't want an orange, that's a different story. But what happened here was there was no orange delivered, and I said, no, I don't need an orange. And the orange wasn't delivered.
So it's apples and oranges.
In my example, yes, Your Honor. This is a Tristan's Landing case, and Hung, or Wong, however the proper pronunciation, and apologies to the actual individual, however you want to say it, there's two parts to that case. And what's important is the sellers is what my sister focuses on. The seller of the home is missed completely in her argument. Specifically, sorry, Your Honor. Hung talks about, in the buyer's agreement, reasonable efforts, and that they will arrange for inspections, coordinating activities. However, in the seller's agreement, what you have was no specification of duration, no obligation imposed. Well, when we go back to look at the actual agreement here, what was not brought up by Your Honors and not addressed by my sister, there's no duration as to the contract either. And Hung requires a duration, and the case law does require a duration. And all the agreement says is that there'll be procure of equity. And my sister does not argue that the document is not a full document that you need to look outside of the four corners of the agreement. So here we have this document. It doesn't specify consideration. It doesn't specify a time limit. Those are two requirements that are necessary to make it a bilateral agreement. So here we have a unilateral agreement where Boston Capital Funding never came to the table with ready, willing, and able buyer that signed a contract and that actually went through and transferred title at an event. And for my sister to suggest that the equity is not included in the Tristan's Landing, equity is certainly property. Equity of a large corporation would be shares, publicly traded shares. Clearly, equity is property and can be bought and sold. It's no different whether it's real estate or personal property. The case of Bump talks about the sale of 80% of a business. Well, that clearly falls within the Tristan's Landing, and we don't have a specified amount of equity, which is another question, certainly as to whether the contract is sufficient. It doesn't have, it has what the compensation will be, but it doesn't say equity up to 10%, equity up to 95%. What is the contract about? For Boston Capital Funding to argue that they're sophisticated individuals, and then you have this agreement that doesn't cover major terms, material terms of what should be in this contract. It is a serious problem, and at best, it's a unilateral contract.
Let's assume for a second that we do think the agreement is exclusive. How is it a defense to BCF's breach of contract claim that Newmark produced debt financing instead of equity?
It is debt financing was not covered by the agreement. That is not equity. My sister suggests that the control of decisions before funds being released makes it equity. What that does is protects a bank's or an individual's investment. It doesn't change that at the end of the day, if the project makes $10 million, they don't get a piece of that $10 million. They get what the note entitles them to. They get repaid, and they get a certain interest rate. And if there's a default, they get a certain default interest rate. But there is no equity. There is no ownership, as we discuss in our brief, how equity is defined. It is significantly different, and it's funding. So therefore, there was no equity given, even if you find that there was exclusivity. There was never equity given or found by Newmark and Nevaeh.
But doesn't the act of contracting with Newmark and accepting the debt financing deprive DCF of the benefit of its bargain with your client?
No, because, again, and are you assuming that it is exclusive? Well, Your Honor, I don't think you can get to exclusive, so I think your hypothetical is improper in this case because you have to make that hurdle. And I see no evidence, and I haven't heard any suggestion from the court as to where in this document that when you look at the cases that there's any inconsideration for or promise to do X, Y, and Z. I promise to list it. This was, I could list it. I could do 20 different things. It's not specifically said I could do these things, but it implies I have the right to do these things. It doesn't mean that he didn't have 5 other deals and was not going to focus on this, but if something fell in his lap, oh, well, maybe I can make 3%. And that's the threshold question here, that to suggest your hypothetical, how can you get there? And that's my response to that answer is we can't get there. The cases are very, very clear on this fact. You look at Harris, details what it takes. Curran, the Des Rivieres, again, apologies for possible mispronunciation there.
Let me ask you this then, and this maybe goes more towards the 93A claim. I know the word exclusive doesn't necessarily mean it's exclusive, but what does it mean? It's kind of sneaky.
Well, Your Honor, to that, I would say that this is a Chapter 93A 11, Section 11 case, and as the trial judge correctly pointed out, experience in the rough and tumble world of industry. And here, there is no question that my sister argues that he is an experienced broker. Well, an experienced broker should very well know what he drafted as far as an agreement. This wasn't an agreement that was shoved down his throat saying, here, you want to do this? Here's the agreement. He authored this. He should know what he is getting into when he authors an agreement, being involved in that field. There's a long line of decisions with respect to brokers' cases.
Isn't that a question of fact for a jury on a 93A claim, though?
No, it is not, because the question of whether a violation rises to the level of 93A is a question of law, as the judge correctly pointed out. So even assuming your example, that in and of itself, even if you assume that to be true, does not rise as a matter of law to a violation of 93A Section 11. And that's exactly what the judge had talked about in her decision. Just because there are representations and certain back and forth made.
But it's not just representations. The allegations submitted by the other party was that they were fraudulent misrepresentations, which, again, question of fact.
Well, they're making fraudulent, the argument made by the other side is that there are fraudulent representations made with respect to the signing of the agreement. And I look at the Bump case, and it's different because there was no fraudulent information. There was no information that said, we don't have anything else, nobody else can get financial lending, debt financing. And that's what it comes down to here. So even assuming that something was there, Your Honor, where would be the damages in that instance? Because we have two different, clearly, debt financing, which isn't challenged here, and equity. So there would be, in your example, even if, which there's not, even if there would be no damages under the 93A. And I don't think you get there because, as a matter of law, you don't. It's not a question of fact, because even assuming true, it doesn't rise to the level under 93A. So that's where the differences are in that question. And I think this very, very closely resembles, and I think I started on the Wong, the seller's agreement. As this court said, there was no specified duration, imposed no obligation on Hong. The defendants were entitled to revoke their promise until performed. Undisputed that the defendants terminated their relationship with Wong before the condition was satisfied. This is absolutely identical. There is nothing different. The word exclusive was there, but again, we come back to that analysis, and you can't get there through that analysis. The Sam Nichols case, Curran, Des Rivers, Julius Tofias, it was binding. In consideration of your listing our property and your promise to make reasonable efforts to sell same.
Okay.
Where is that in the agreement? It's just not there, Your Honor. Therefore, I believe that the court correctly ruled on this. And to answer a very quick question, I don't believe that the bond issue is properly before this court.
Okay. Thank you.
Thank you.
Thank you both. We'll take it under advisement. With that, I'd like to thank our court staff, our court officers, our clerk's office, our law clerks, my colleagues, and our excellent timekeeper. With that, we'll stand in recess.